out of session from Friday, my lord, for 5 days. For my son admission. So my lord, definitely taken on tomorrow, my lord.
Just give the filing number.
Yes, filing number I have given.
My lord, matter relates to selection and appointment of handicapped candidates, my lord. In this case, my lord, we are asked to file an application for implement. Implement has been allowed, but no notice has been issued in the case, my lord. So may I pray
Friday.
My lord, the similar prayer for Friday, my lord, for withdrawal, my lord. Obliged.
May I please, Your Lordship? Lordship, I'd like to mention 2 matters for listing in admission column, Lordship. Last listed in the month of March and May, Lordship. Appointment, Lordship. Any date, Lordship? Monday,
25th.
Lordship.
25th.
Lordship. Obliged.
May I please, Your Lordship? I'm also praying for listing of a matter, Lordship, admission column next week, any day.
25th.
May I please, Your Lordship, I beg to mention item number 31, my lord. During pendency of the writ petition, my lord, I got relief, my lord.
Wait for some time. Let the mention be over. We'll pass the order.
May I please, Your Lordship? Item number 11 and 12, my lord. This matter may be adjourned, my lord, because I could not contact with the petitioner, my lord. Some instruction and have to be required regarding their condition of service, my lord. Maybe some petitioner.
Let the matter reach because 2018 matter. We'll accommodate you. Wait for your turn.
Your Honor, kindly, I want to mention item number 32 for adjournment. The senior is in leave.
Have you informed the other side?
No, Your Honor. Lordship.
Why? When do you want?
After 2 weeks,
What's your good name?
A. Banerjee.
On behalf of Mr. Ransom.
My prisoners. My lord, this matter listed last on my lord 26/9/2022. Despite direction of this court, my lord, this matter is not being listed, my lord. May I pray, my lord, maybe
This will come for admission or order?
admission, my lord.
Monday.
May I please, Your
Hello,
Lordship?
President.
Lordship, I beg to mention item number 14 to 25 series matter, Lordship. In this case, UKNIR is engaged counsel.
See, there was a notification earlier. The lists are published 2 days ahead, right? If you want to make a mention, you should tell us at least a day
Some
prior.
personal
Because,
problem he could not.
no, definitely. It's to all the members of the bar. We have to do lots of homework at night after going from here. We leave here around 8:45, 9, and you do not tell us. Anyway, we can accommodate you, but from the next time onwards, whoever wants to adjourn a matter, at least indicate our bench assistant in the previous day. That was the system, in fact.
On next Monday, maybe fixed. Interim may be continued.
Yes. Next.
May I please, Your Lordship? I just mention item number 28, Lordship. In this case, Your Lordship, respondent has filed an affidavit in opposition. Will file a rejoinder, Lordship, after 2 weeks.
When the rejoinder was filed?
No, will file affidavit opposition.
Yes, when the affidavit was filed.
29th May, Lordship.
Three one.
Submitted by Mr. Law. During pendency of this petition, petitioner has prayed for it as such. It's not this.
I have been promoted, my lord, and transferred to Namrup, my lord.
Learned counsel appearing for the petition.
2314.
Corresponding numbers to on instruction of the petitioner. Counsel not pressing this. The interim order passed earlier. 10/10/2008, suspending the operation of the memorandum number PBFC of Lexio public marketing MKTEG M capital public 170 that is 01/01/10/2019. Chief Personnel Officer W of the Brahmaputra Valley Fertilizer Corporation Limited. Namrup personnel.
Can a line may be indicated? My lord, can a line may be indicated, my lord? I have been promoted and now posted at Namrup. Promoted as DGM, my lord.
During pendency of this petition has been promoted as
Deputy General Manager, Marketing.
Deputy General Manager
Marketing. Within bracket,
Marketing.
marketing.
Within bracket. And posted at
Namrup.
Namrup.
I am obliged, my lord.
Mr. Ko, what's the matter about?
Your Lordship, the petitioners, Your Lordship, the deceased husband was the tax collector and he retired. Your Lordship, he was given pension from the date of regularization, Your Lordship. And he agitated that matter before this honorable court. Your Lordship, a writ petition was filed in the year 2019, Your Lordship. In that writ petition, Your Lordship, while it was disposed of, this honorable court was pleased to direct the state to make a pensionary benefit from the date of initial appointment, full pension, Your Lordship, along with 6% interest per annum, Your Lordship. Subsequent to that, Your Lordship, the commissioner of the PNRD, Your Lordship, wrote a letter to the pension director of pension and public grievances for releasing the pension in compliance with the judgment passed by this honorable court in the earlier writ petition, Your Lordship, in WPC number 226/2019, Your Lordship. Your Lordship will get this judgment at page number 76, Your Lordship. And the operative part is, Your Lordship, will get in the page number 78, Your Lordship. The last paragraph, paragraph 9, Your Lordship. In view of the above, as the petitioner is entitled to count the entire length of service for pensionary and other benefits under aforesaid act, the authorities will work out the entitlement of pension and DCRG and accordingly issue fresh orders in supersession of the earlier orders issued by the authorities, which exercise shall be undertaken by respondent authorities within a period of 2 months from today. The aforesaid amount due will also bear interest at the rate of 6% per annum.
Yes.
Thereafter, Your Lordship, the commissioner wrote a letter to the Director of Pension, Your Lordship, for compliance of as the decision has been taken, the Department of PNRD, and he was requested, the Director of Pension was requested to make full pension to the then petitioner, Your Lordship. It was written, the letter was written the 11th of July 2019, Your Lordship. Your Lordship, this is the copy of this communication. Thereafter, Your Lordship, we have written the letter in the July 2019, in the Director of Pension has written a letter on 22nd of March 2021, saying that, Your Lordship, some clarification is required because there is a government notification dated 1/6/2004, which says that the ad hoc period would be deducted in counting the pension, Your Lordship. That clarification, that letter was on the 22nd of March 2021, Your Lordship. Thereafter, Your Lordship knows it well, Your Lordship, the COVID situation is has been arised then, Your Lordship. Then, Your Lordship, some elapsed, time has been elapsed on our part, Your Lordship. Now, Your Lordship, we have complied with the judgment dated 3/4/2019, Your Lordship. This is the order, Your Lordship. This is the communication made by us to the. This is the communication. Your Lordship. The recent one. July 14th, 2023, Your Lordship. It is issued by the Commissioner, Panchayat and Rural Development. Since he is the grade 3 employee, Your Lordship, grade 2. So his authority is, Your Lordship, the controlling authority is the Commissioner. So, Your Lordship, the PNRD department, Your Lordship, take the decision, Your Lordship, for payment. Now the Director of Pension is requested by the Commissioner for payment, Your Lordship.
Please take your seat. Mr. Kaur, can you tell us why in two of the letters,
Yes, Your Lordship.
the service of the petitioner was stated to be ad hoc?
Your Lordship, at the time of initial appointment, Your Lordship, it was not a regular employment. Your Lordship. Subsequently, his services regularized. Your Lordship.
Regularized with
The yes, at 1991, Your Lordship. 1991.
now why his service was not regularized?
Your
Why
Lord,
his service was not?
yes, Your Lordship.
Why his service was not regular?
Your Lordship, it was because it was not regular employment, and subsequently Provincialization Act came into force, giving effect to the 1991. And such type of employees, those who are working against some post or some were not even working against existing post. Even then, Your Lordship, the
But the
state has
division-
taken the decision to provincialize and
But
regularize
the
them.
division bench have clarified the matter.
Yes, Your Lordship.
But the division bench have clarified the matter. which was
Yes,
upheld
Your
by the
Lordship.
Honorable Apex
Yes, that is why, Your Lordship, the subsequent the learned single judge, Your Lordship.
We want to know the reason, in spite of the division bench judgment upheld by the
No, no.
Honorable Apex Court, why
No.
the petitioners?
No, Your Lordship,
Pension
Your
was-
Lordship, from the 1991, Your Lordship, kindly. Regulation, regulation order. His date of appointment was 1963, Your Lordship.
Hmm.
And very provincial, right?
From 63 to 91,
91.
18 years, why his service was not regularized? Regularized because of the relevant act came into force,
Yes, Your Lordship, regularized because of the act, Your Lord, Provincialization Act.
but the division bench have given a different view. They are entitled from the date of their joining.
Initial appointment, Your Lordship.
If it is
Yes.
so,
Yes.
why the petitioner's pension have this particular employee was serving in the period was assessed in from the date of his regularization?
Your Lordship, the
See, we want to know the reason. That has to be when the judgment has been
Yes,
passed, upheld by the Apex Court.
yes, Your Lordship.
The petitioner's pension should have been assessed in terms of the direction of the court.
Your
He is a
Lordship,
mere
the
tax collector. For that, why should he approach the court again?
Your Lordship, in the 2019, while the learned coordinate bench has directed us to make payment from the date of initial appointment. So we have taken the decision. And we have communicated the same to the director of pension, Your Lordship. I have given the communication, Your Lordship, dated 11th July 2019, Your Lordship, sent by the Commissioner, Concerned Rural Development to the director of pension, Your Lordship. We have taken the decision then, Your Lordship. 11th July 2019. I have provided two sets of papers, Your Lordship. First set, Your Lordship. 11th of July 2019. Your Lordship. Joint Director, Commissioner, PNRD. Then we have taken the decision. In response to our letter dated 11th July 2019, Your Lordship, the Director of Pension has written a letter to us on 22nd of March 2021, Your Lordship, seeking some clarification from the government, because there was a notification dated 1/6/2004, whereby it was which provides Your Lordship for deduction of ad hoc period in counting pension, Your Lordship.
Now, pursuant to the letter of the Directorate of Pension of 22nd July, 22nd of March 2021, where
Yes,
is your
Your
reply?
Lordship. Yes, Your Lordship.
Where is your reply?
Your Lordship, yes, a letter was in response to that letter, Your Lordship, a letter was written by the Joint Director to the government seeking the clarification, Your Lordship. In the meanwhile, Your Lordship, as the COVID period started, Your Lordship, ill normalcy is arised, Your Lordship. Yes, we have made some mistake, Your Lordship. Your Lordship is aware of the official process,
Now,
Your Lordship.
thereafter, what happened?
Thereafter, Your Lordship, now we have taken the decision and giving the clarification to the Director of Pension, and
Where is the letter to the Director of Pension? Last out letter.
the last letter, Your Lordship, 14 July 2023. I have provided the letter, Your Lordship, issued by the Commissioner. 24th of July 2023.
Who is appearing for the Directorate of Pension? Appear.
Your Lordship may kindly see the next page of the 14 July 2023 letters, the next page, Your Lordship. A letter issued by the government to the Commissioner, Your Lordship, where it is said that the government has taken the decision for payment, Your Lordship, full pension.
Mr. Kaur,
Yes, Your Lordship.
furnish a copy of this two letters, the government letter of
In the Commissioner, the letter.
12th of July.
12th of July. Yes, 12th of July letter.
And your communication of 14 July,
Yes, yes.
the Directorate of Pension.
Visible copy. Yes, sir.
Give it
I'm
to him.
sorry.
No, give it to him. And
11 July letter. 11 July letter. 11 July. 11 July letter. 12 July. Wait, no. এখন সব
When the husband of the petitioner expired,
Your Lordship,
yes, madam, when the husband of the petitioner expired,
In the year 2019, Lordship.
expired on 2019.
Lordship.
no. He, yes.
I'm
sorry.
Letter, but.
Yes, it's a special case. The person retired February 2000. Right? Produce the PPO or the next day in terms of the judgment of the past 5 years.
So the updated PPO.
Absolutely. We are fixing this matter on 8th of August.
8 of August.
Prepare it. Produce the original PPO. Yes, ma'am. Where is from the petition?
Lordship.
Petitioner is from which place?
Lordship in Golaghat, Lordship.
You appear, accept the PPO. Produce the PPO on the date. MS Sambhava, Land Council appearing for the petition, and Mr. K. Kumar, Standing Council, PNRD, or Senior Standing Council,
Senior Standing Council, PNRD.
for the respondent numbers. Which for finance? Okay, Italy. You are appearing for B. Gogoi?
Yes, sir.
B. Gogoi, Standing Council Finance. Put her name. on behalf of- For the respondent number 3, 7. You will appear for, Mr. Roy will appear for respondent number 2, mentioned in public grievance. You will appear student five. What's the name of the madam?
MS Puspanjali Das, Your Lordship. Secretary, PNRD. Your Lordship.
Secretary PNRD.
Yes, Your Lordship.
MS. It's personally present before the court. In terms of the 3006. Matter relates to payment of pension as well as family pension. Payment of pension to the husband of the petitioner as well as family pension to the petitioner. Late husband of the petitioner was a tax collector under Golaghat Jilla Parishad, and he retired from service on 28/02/2000. However, his pension was assessed considering his length of service from the date of provincialization of service, i.e. 1/10/1991, in spite of the decision of the court passed by Honorable Division Bench on 24/03/2010 in the appeal number 145. Common judgment order.
Your
Appeal number
Lordship,
such and such. Appeal number 145 of 2009 and other connected cases
Your Lordship,
that was upheld by the Honorable Apex Court, while order dated 02/08/2010, passed in special leave to appeal in bracket civil numbers query 19351-19360 of 2010. Earlier, the petitioner husband during his lifetime preferred a writ petition for a correct assessment of his pensionary benefits being and to pay this being WPC number 2226/2019 that was disposed of on 03/04/2019 in terms of the division bench judgment dated such and such, first in appeal number 145/2009, the bracket state of Assam purchase, state of Assam and another purchase. Shahid Muhammad Fazli Rafi directing to determine net pension of rupees 2136 and to pay the necessary pension as well as the CRG accordingly to him with an interest at a rate of 6% per annum. In spite of the said order of the court dated 03/04/2019, passed in WPC number such and such, as the respondent authorities in the PNRD did not pass any necessary order requiring to pay full pension to the husband of the petitioner expired on 06/02/2019. As such, it is the petitioner after the said order dated Natali during the pendency of the said writ petition WPC number 2226/2019, husband of the petitioner expired on 06/02/2019. And as such, it is the petitioner who took up the matter with the responsive department. Mr. Kumar, senior standing counsel, PNRD department, placed before the court a copy of the communication number CPRD/LC/36/2019 dated 11/07/2019, whereby the joint director of the PNRD department informed the Directorate of Pension to pay to assess the pension payable to the husband of the petitioner at rupees 2136 in terms of this court order dated 03/04/2019, to which the Directorate of Pension by number WPC 226/2019 dated 22/03/2021 made some queries from the PNRD department. It is admitted by Senior Standing Counsel PNRD, Mr. Ford, that because of the COVID-19 and thereafter, there was a delay on the part of the respondent authorities in the PNRD to process the matter again with the Directorate of Pension. However, Mr. Ford and the concerned secretary present before the PNRD Republic Court sought for a follow-up in their part for such delay. Mr. Korn and Senior Standing Counsel placed before the court communication of the state government in the Panchayat PNRD department dated 12/07/2023, issued under number 254154, whereby the commissioner and PNRD was directed to work out the total financial implication by counting the total period of service with respect to the husband of the petitioner. So that it can process with the payment of pension to the husband of the petitioner, as well as family pension to the petitioner in terms of this court's order dated 30/06/2023, passed in the present proceeding. Accordingly, the matter was settled at the end of the PNRD department, and thereafter, by communication number CPRD/LC/163/2022/133, dated 14/07/2023, the commissioner of the PNRD department informed the Directorate of Pension, indicating the letter of the state government in the PNRD department issued on 12/7/2023 under number ECF 254154 to grant full pension and pensionary benefits, including DCRG, taking into account the entire service rendered by late husband of the petitioner from the date of his initial appointment on 29/10/1963 till the date of his retirement on 28/02/2000, without any deduction from the initial period of service. Providing a copy of the same to the petitioner hearing. Your good name?
CS Hazarika.
Mr. C.S. Hazarika, London Government Advocate Assam. Mr. Korn, London Senior Standing Counsel PNRD, on instruction of the court, as directed by the court, submit the communications of the government in the PNRD department dated 12/7/2023, as well as the letter to the Director of Pension dated 14/07/2023, issued by the Commissioner PNRD department to Mr. C.S. Hazarika, London Government Advocate Assam. On the next date fixed, since the late husband of the petitioner retired from service on 28/02/2000 and has also expired on 26/02/2019, considering it a special case, the Director of Pension, respondent number 5, is directed to request pension pay order What is the earlier pension pay order?
Page 63.
Treasury.
Golaghat,
Golaghat Treasury.
Lordship.
To issue a fresh pay order and to place the same before the court. Place pension pay order of sick or earlier pension petitioner, namely person, as well as family pension pay order in favor of the petitioner on the date that fixed in terms of the communication dated 14/07/2023 issued by the Commissioner, PNR Department, deducting the amount already paid to the late husband of the petitioner for his pension as well as family pension. Based on some more time will give in 22nd of Mr. Goswami. Okay, we'll give you a copy of it. Copy of this order. Furnished to CS Hazarika government. Mr. Hazarika, produce it before the court. Mr. Gogoi, on the next day, you have to inform the concerned representative once Mr. Hazarika produces the pension pay. Both whatever was payable, the petitioner's late husband of the petitioner, as well as what is to be paid to the petitioner, considering the amount. Do you personal appearance of person until further.
On the next date, your lordship dispense with personal appearance.
And also in terms of the order of the president.
Yes, your lordship. Lordship, here in the petitioners are the master workers. They are engaged in irrigation department of Mongoloi. Lordship,
What is your
some of their wages they were not paid for a certain period of time. Lordship. For that petitioners beg to state that Lordship page 5, paragraph number 5.
Where is the statement you have said? Have you given a chart for which period you have not received?
Lordship, yes. Lordship, actually the respondent number 3, they have prepared a chart. Lordship. Page 14.
So you are claiming your area till it.
Yes, Lordship. Area. Lordship, the respondent number 3 has also made a part payment for the same period of rupees 38,440. Lordship, it's on page 18, Lordship.
Let's take it. Yes, please go to the judgment passed by the division bench of this court. Surrender Sundranath. The case reported in 2013 to JLT 1094. Whether you are entitled for.
Lordship, that actually, Lordship, the claim has been made after 3 years. That we know.
So how in a writ petition we can consider?
No, Lordship, a similar order has been made by the Lordship learned Justice L.S. Jamid. The
It is
period
not possible because the division bench has passed that order and we cannot go beyond the division bench.
Lordship, we are not going for mandamus, Lordship. We are just going for direction.
We cannot pass any edict. We will not entertaining this petition because your claim is beyond 3 years. You approach the government. We prefer a suit, whatever you want. We will not interfere in it.
Lordship, direction may be given, Lordship, to
We are not
consider
giving any
your.
direct. Sorry. Some court may pass, but this court will not go beyond the division benches. Morely, thereafter there are Supreme Court judgments. Honorable Apex Court have laid down. There cannot be any claim beyond 3. That was in some of the cases, in exercise of the power under Article 226, the courts have issued direction. Court have passed mandamus. So the Honorable Apex Court has clearly laid down that in exercise of the power under Article 226, neither the mandamus can be issued nor such directions have been given to the government. It is up to the concerned claimant to approach the appropriate forum beyond 3 years period. Even the amount is at stake. Find out. It's up to you. Law is well settled. We will not go beyond that. Somebody exercising that power benevolently, that is particular to that court. We have nothing to say. But we will not go beyond the division benches.
If the response will not also.
You know what to do. You know where to approach. You have the proper forum. It's up to you. Either you withdraw or you dismiss.
The Lordship then will withdraw.
See, difficulty is the duty of the standing counsel of the government advocate to place the relevant judgments before the court, which is applicable. We do not want any government advocate or the standing counsel to just a mayor, a standing counsel, standing in the podium, nothing else. Either you appear rightly or we dismiss or we allow the priority petition. Take it from this court. You have to be vigilant, prompt. That is the responsibility you have been given. Third, Mr. As thus counsel for the petitioner. Petitioners.
Kedas, Lordship.
Sorry, Kedas. And Mr. MS.
DS Nugget.
Standing counsel irrigation. For the response numbers 1, 2, and 3. Petitioners hearing are master roll workers under the Mongoloid division within bracket irrigation and stated that they have been serving since September 1994. However, the authorities in the irrigation department did not pay their salaries for the period from 01/04/2000 to 31/10/2000 in bracket for 7 months, and 01/11/2000 to 30/04/2003 in bracket for 30 months. Hence, this writ petition by the petitioner filed on 06/06/2023, claiming their arrears relief for the said period. The division bench of this court, in the case of Harendra Chandra Nath versus State of Tripura, reported in 2013 to GLP 1094, have held that the claim of any such allowances or arrears relief beyond 3 years prior to the filing of the writ petition cannot be entertained. No such direction and mandamus can be issued in exercise of the power under Article 226 of the Constitution of India. for payment of any such to the respondent authorities for payment of any such salary beyond the period of the generic proceeding. Considering the since the claim of the petitioner hearing for the arrears hearing for the period as is for the period from 01/04/2000 to 31/10/2000 and 01/11/2000 to 34/04/2003, much beyond previous period. The claim of the petitioners cannot be entertained. At this stage, Mr. K. Das learned counsel for the petitioner on instruction of the learned counsel on instruction of the petitioner.
Matter regarding family pension.
What happened?
Petitioner is the second wife, Lordship, and decision number 8 is the
How you are entitled being the second wife?
Lordship. As per division bench,
Where you got married? Where is the marriage certificate?
Lordship, page 15, Lordship.
Page 18.
15, Lordship. Pension payment order, Lordship. Page 15, Lordship. 15.
Page 15.
Yes, Lordship.
What do you want to show from page 15?
Lordship, last Lordship. Number 1, Samartha Khatun, first wife, and Asiya Khatun, petitioner is the second wife, Lordship.
When
Then,
did you
Lordship,
got married? Where is your marriage certificate?
Lordship, I have not annexed, Lordship. Next, Lordship, page 18, Lordship. There is a correspondence, Lordship, regarding name, Lordship. Page 18, annexed 3, Lordship. Then, Lordship, page
Kindly
19.
tell us,
Lordship,
when you married the husband, where is the marriage certificate? You need to see.
Lordship, I have not annexed, Lordship, but I
Produce it.
have the marriage certificate, Lordship.
You have.
Marriage was formalized on, Lordship, in the year 1989, Lordship.
Yes, tell us. Do you have a copy of the writ petition?
Yes, sir.
Kindly come to page 15.
First and foremost, Lordship,
Please come to page number 15. Mr. Dhar,
My lord,
come to page number 15. It's a pension pay order.
my lord.
Date of joining of the service of the late husband of the petitioner.
My
You
lord,
can see at serial number 5 is 13th of June 1975.
75, my lord. Retirement 2012.
Please see the marriage certificate to be given by you, your friend here. Just here, it's not annexed. Date of marriage,
89.
when,
89, my lord.
so during the service, what is the law?
They have to seek permission, my lord. Has to be, my lord, notified to the department.
Has to be. So, the service law, whether it's central government or state government,
My lord.
doesn't allow to have a second wife. So whether the petitioner will be entitled for the pension, even though the division bench judgment is there,
Yes, my lord.
that aspect of the matter was not considered.
Yes,
But
my lord.
subsequent to that, whether Justice Chaudhary during his lifetime a passed judgment which reported that. In fact, the Supreme Court in a similar matter has upheld that if the service law doesn't provide to have second wife during the service career, not required. Honorable Justice Goel judgment is there, it was been subsequently followed.
Yes, my lord.
So tell us how you are entitled.
I am following the division bench lordship.
That division bench judgment, if you read, this is error. That aspect was not considered. It was not property knowledge of his lordship. That has been considered. That aspect has been considered by Justice and Chaudhary during that the reported judgment in the theory.
Let me go through the judgment.
Please. You are guided by which service? Your husband?
Yes, no.
Sericulture department lordship.
No, what you were? I was. কি কাম করছো না? সেরিকালচার না? আসাম মিনিস্ট্রিয়াল সার্ভিস হবে। My lord, let him survey a copy, my lord. I was not survey a copy. Just I don't know, my lord.
That was said. Okay, we'll make it.
I don't know actually, my lord, what is the material about.
Or Mr. Asalo, counsel appearing for the petition. Mr. C.S. Azrikal and some for the response.
7. 1 7.
I will apply for 2, 3, and 4, my lord.
Also heard Mr. R. for standing counsel for the sericulture department. Some respondent was
2, 3, and 4, my lord.
You are appearing for whom? And Mr. P. Gugui, extending counsel finance. For the respondent. Petitioner is the second wife of Mr. Ob Asiruddin Sheikh. Was serving as what?
Manager lordship in sericulture department lordship.
Was serving as what?
Manager as sericulture in sericulture department lordship.
Manager.
Yes, lordship. Under the respondent number 4 lordship.
The sericulture department. The office of under the assistant director of sericulture department. Retired from service on 31/03/2012 and expired on 29/05/2021. Petitioner stated that as per the pension pay order number 10065111220029 issued in favor of her late husband reflect the name of the respondent number 8 the first person of the petitioner, namely Asiruddin Sheikh, and her name as the second wife. From the pension pay order issued by the Accountant General A. Assam in favor of the husband petitioner Assaruddin Sheikh. Annexed to this petition as Annexure 1. It is seen that Syed Assaruddin Sheikh joined his service in the Sericulture Department on 13th of June 1975. Though the petitioner did not annex the marriage certificate between her and Syed Assaruddin Sheikh, but on being inquired, Mr. Alam, learned counsel for the petitioner, showed a marriage certificate between the petitioner and Syed Assaruddin Sheikh. It was executed on
5389.
5th of March 1989 during the service tenure of Syed Assaruddin Sheikh. On the next date fixed, the petitioner, by filing an additional affidavit, list on 4th of August, the petitioner on or before 02/08/2023 by filing an additional affidavit shall incorporate our marriage certificate with Syed Assaruddin Sheikh. Serving a copy of the same. It is seen that the petitioner hasn't served a copy of the writ petition. The annexes appended to the Standing Council, Sericulture Department, while filing this petition. As such, Mr. Alam, learned counsel, direct to serve requisite copy of this petition, including the annexes appended to Mr. R. Dhar, Standing Council Finance. Sorry, Standing Council Sericulture. For the respondent numbers 2, 3, and 4, right?
My lord.
During the course of the day. On the next step, the petitioner shall also apprise the court as to how she is entitled for pensionary benefits, family pension, being the second wife of late Assaruddin Sheikh, being married during the service tenure of being married during his service tenure.
Deep replacement. My lord, my name may be shown in the causes.
This is a respected name, sir. Standing Council, Sericulture Council for the
Deep replacement.
My lord, may not take this matter, my lord.
Say, whether the petitioners applied
My lord,
in terms of the advertisement issued by the Director of Elementary Education on 1st of February 2015 and 14th of February 2015.
pardon me, my lord.
Whether the petitioners applied for their salary, there was a direction
My lord,
in a suo moto writ petition
my lord,
by Division Bench of this court,
my lord.
Manoj Kumar Sharma.
My lord, in terms of the order passing,
Pursuant to that,
my lord,
the Director of Elementary Education Assam on 4 specific dates in the year 2000, February 2015, it so that advertised to all such teachers appointed during the tenure from 1991 to 2001 who did not receive their salary.
my lord.
Whether the petitioner
My lord, with that, my lord, I have no clear knowledge, my lord. But in terms of the court order, my lord, passed in this recently, my lord, by Lord, my lord, Vijaypura, sir, my lord, some inquiry was going on, my lord. They had appeared before the inquiry court, my lord.
there is a specific direction in that division bench also, pursuant to which the Director of Elementary Education is attached.
My lord, I'll have to apply.
So basically,
Lordship, here we have filed our affidavit, Lordship. Some of the petitioners have participated, but they didn't fulfill the criteria. But some of the petitioners, petition number 10, 12, 13, 17, 18, 19, 22, 23, 26, 28, 29, 40, some of the petitioners, they did not. We have filed our affidavit. But they did not, those who although participated, but they did not fulfill their criteria as per the cabinet memorandum, Lordship, of receiving salary up to 2007. So their candidates were not.
the rest of the petitioners did not apply.
No, Lordship. There is no record. As per my instruction, there is no record. Perhaps my learned friend would be able to collect that information from those petitioners, whether they appeared or but in the screening committee, there is no report of their appearing in the screening committee, before the screening committee. To that extent, we have filed our affidavit, Lord. There are 80 writ petitioners here. Almost 37 writ petitioners, they did not appear. Their records are not before the screening committee.
What is the period for which you did not receive salary?
My lord, from the date of their regularization, my lord, 28, 2015, my lord. Sorry, 2005.
28,
2005.
on the date of their regularization.
Where is the order of regularization?
My lord, possible time, my lord. That is case 37, my lord. That is from 36, my lord. My lord was there, my lord, during the proceeding. In fact, my lord, some of the petitioners, my lord, not petitioners, my lord, the candidate, my lord, whose service was regularized, my lord, they had approached before this court, my lord, and they got some orders, my lord. May I please, my lord, on copy of the order, my lord, who were commercialized by this order, my lord.
A detailed affidavit has already been filed. So in terms of this,
My lord, I will file counter, my lord.
You want to file counter?
Yes, my lord. I know it on day before yesterday, my lord.
Was there any appeal against
Yes,
in this?
yes.
What is the division bench order?
Division bench has reverted back to consider the case a fresh matter.
Just so.
Our appeal number was 179. There's several, my lord, several appeals were filed, my lord.
Which is your read appeal?
179. It should be marked, my lord, underlined.
171, you say?
My lord,
You read appeal number?
179.
The Commissioner Secretary, Government of Assam has filed a detailed affidavit in this matter on 17/07/2020. List for admission on 10th of August. In the meanwhile, petitioners may file their reply if any on or before.
my lord, can it be a little longer, my lord? Can be little longer, 24th, my lord, August, date, my lord. 24th,
So why do you want to think?
I need some time, my lord. 24th of August.
17th of August. But file your reply on or before.
My lord. Obliged, my lord. And there is an order to be made. They were, my lord, also regularized, my lord, by the same order. Let me keep the city.
Let's say because it is case to case varies.
My lord.
Let's say that the relevant time.
Here, Lordship, as per my instruction, petition number 1, 2, 3, and 4 has been accommodated, Lordship. Pursuant to the cabinet decision, Lordship. Accommodated as teacher, but there is no instruction as regard petition number 5. So perhaps we need to file our affidavit also here.
I have also no instruction.
Right.
Deepak bola na? No instruction.
Rajan Gugui, Ramesh Phukan,
You teacher na?
Rajat
Yes.
Das.
What is the decision of the committee? You are seeking salary from March 2012.
12 years, Lordship. I was till the date of filing, Lordship. From March 2012 till the date of filing, they have not getting their salary. Just continuous.
Teacher.
Yeah, just previous.
Teacher. 21.
With regard to Sibsagar,
Lordship.
Yes.
Mr. Gogoi will also be knowing. With regard to Sibsagar illegal appointments, there are access appointments. There are some decisions are taken by the government.
Some
decisions-
supernumerary posts were created and they received salary up to certain period, Lordship.
But they are also supposed to appear because
They appeared, Lordship.
They appeared.
They appeared before the screening committee, and the petition number 1, 2, 3, and 4. They fulfill the criteria as per the cabinet memorandum, and they have been accommodated as teacher.
what about the rest?
Only 5. Petition number 5 report is not there today, Lordship. Lordship may allow some time, and we will obtain instruction.
So 1 to 4.
1 to 4, they have been accommodated as teacher.
Now, with regard to 5, you do not have the information.
Today, Lordship, I don't have the instruction with regard to petition number 5, Lordship. Whether he appeared or not, there is no report of either appeared or non-appeared. Petition number 1, 2, 3, and 4, they have appeared. They fulfill the criteria as per cabinet memorandum, and they have been accommodated as teacher.
But they have not received their earlier salary, Lordship.
Earlier salary to
But
with
in
the
terms of the
prospective
cabinet decision,
cabinet decision with prospective effect.
Yeah. এটা মোৰো নাই।
Mr. Rupai has standing council elementary responding
PN
members
Sharma.
1, 3, 4, 5, 6. Whereas Mr. B, who was standing council finance for the respondent number.
এক্সট্রা কপি
Number
কি নামটো?
Pursuant to the orders passed by division bench of this court, WPC number 1048/2004. The Director of Elementary Education Assam on 01/02/2012 as well as 04/02/2012 issued advertisement in the newspapers circulated in the state, inviting applications for those teachers appointed during 1991 to 2001, but did not receive salary. Thereafter, the screening process was initiated through 5 screening committees headed by the divisional commissioners concerned and principal secretaries in the 6 scheduled areas as well as the BTC area. Thereafter, reports were submitted. Five screening committees in Upper Assam Division, Lower Assam Division, North Assam Division, Hills and Borak Valley Division, and BPC. They submitted the report. On the basis of the reports of the divisional screening committee, verified the applications and submitted a report after the recommendations after such verification screening by various zones, verification and re-verification. 4 categories of teachers were set out, where number 1, category 1, with 136 candidates recommended and found working. Category 2, of 250 candidates recommended but discontinued its job. Category 3, with 8470 candidates not recommended but found working. And category 4, with 2900 candidates not recommended and discontinued the job. Out of that, decision was taken by the government in its cabinet to regularize the service of the teachers found under category 1, and accordingly their services were regularized. The second category of teachers were recommended, but Mr. Upadhyay, understanding council.
Lordship,
Appearing.
PN Sharma, Lordship.
Sorry, I'm PN. Submitted. On instruction submitted that with regard to the petitioners number 1 to 4, they have been duly recommended by the steering committee in the category 1, and accordingly their services have been
Recommended as teacher.
as teachers.
But Lordship, the petition number 1, he did not join.
But,
Petition number 1 did not join.
but the petition number 1, Rajan Gogoi, did not join his
Lordship. And rest three, they have appointed and they accepted the appointment.
Respondent number 2, 3, and 4
Did not join, no?
accepted their appointments. Mr. Sharma submitted that with regard to the petition number 5. As to whether he appeared before the screening or not. Report is there. List on. Please. 8th of August. The respondent is authorities in the elementary education department file a detailed affidavit in the matter. On or before 4th of August.
The main issue is regarding area selection. Here, since 1 to 4 has been now accommodated, pursuant to the cabinet decision, there is a condition that they will not claim for area. That part,
We will not say that. Let them submit
Yes,
the affidavit. Then we will pass the law of acquiescence. Read the law of acquiescence.
waiver and acquiescence.
The law of acquiescence is something very special.
Five is also same.
Here also we received instruction, Lordship.
Similar. Shivsagar.
Lordship Shivsagar. So here also we may be allowed to file affidavit because some of the petitioner have been accommodated.
Okay. The matter is similar to that of the
Lordship.
that of the application number 5129 of enabling the respondents in the ability to file their appeal.
Respondent education department will file the affidavit.
Affidavit we will file.
8, Lordship.
6 is also same.
Move to 5 also.
6 is also same.
Lordship, this is from Shivsagar and non-payment of salary. Lordship.
6 is same.
This is also same, Lordship. Here all the petitioners has been accommodated. Some of them has been accommodated as teacher because they
Give us the details in your
we
affidavit.
will file our affidavit.
We have given you time. Same as
Lordship. Only one he did not accept the appointment.
give us the details.
Lordship, we will file affidavit, Lordship. Yes.
Before 4 you have to file.
Lordship. Okay.
The matter may be taken on next week. The engaged counsel is unable to present due to her personal difficulty.
Can I have the second copy? Actually, I have just applies the court. But otherwise, my lord, illegal appointee, my lord, terminated. In para 2, my lord, their own admission, my lord, that they were not appointed pursuant to a selection. There is no statement that, my lord, pursuant to a selection they were appointed. we are yet to file our affidavit. The series by similar terminations were put to challenge. It has been heard, and in Code 17 it has been reserved for judgment relating to health department. Same grade 4 employees, they were terminated.
No, there is terminated because of that.
Screening committee, the Lordship was Lordship with others, they appeared, they are found to be not genuine, and they were terminated. In fact, from 2002 there was a ban period. In that period, the petitioner number 2 seems to have been appointed. And that part, the rules.
Tell us one thing. That matter has been, whether that matter will cover the case of the petition.
Otherwise, some individual will have to file the affidavit because whether their appointment letters, whether they were genuine or not, what is the finding that will have to place. But one thing, by going by the writ petition, there is no averment or their assertion that they have been appointed pursuant to proper selection. In fact, the Mamta Mohanty's case covers it. Without advertisement, there cannot be any appointment.
Mamta Mohanty, Umarani, all this.
Yes, sir. In fact, there are orders of this honorable court, where the motion stays as case has been dismissed, relying upon Mamta Mohanty, because they ought to have at least made a statement that they have been selected, pursuant to selection.
But unless you file your affidavit.
Yes, I will bring it into record.
But today is the date fixed for your submission. The court have already recorded the submission of Mr. Gogoi on 26th of June.
Lordship engaged advocate is unable to present. Lordship engaged advocate is unable to present. I am appear on behalf of Ms. B. Talukdar. So,
Appearing on behalf of Mr. B. Talukdar.
Mrs. B. Talukdar.
This matter is also part of that particular series.
No, it was not. And in that series, where affidavit has been filed, always clubbed together, and it was hard. Except 2 districts in the series, Dibrugarh and Morigaon, where there was a proper selection at the district level, but without the approval of the government. So that plea we have taken in those cases. Rest of the cases, without any advertisement selection, they were appointed.
Tell us when you file your affidavit.
At least 2 weeks may be given.
Tell us when you file. Give us a date.
Yes, sir. It will be in 3rd week of August. On 21st of August, before that, we will file an affidavit.
What's your good name?
P. Boiregi.
On behalf of the respondent authorities in the Health and Family Affairs Department shall honor before. Today is 19th. So by 3rd. By 3rd.
Lordship, 19th. 3rd of August,
List on 8th of August.
Lordship will give us time till 7 in that case. Let it be on 11th in that case.
Okay, on
by 7 we'll file an affidavit.
List on 10th of August.
Right. Obliged.
Okay.
Is your Lordship? Lordship, may kindly pass over for the timing. Kindly pass over for the timing.
Here, my lord, all the petitioner has accommodated, my lord.
File your affidavit.
My lord.
Otherwise, it's difficult.
My lord, I'll file. And they have also accepted the.
Okay, you just place it. That will be easier for us.
My lord,
Otherwise, things will be different.
I'll.
Because you have to place their acceptance first.
My lord,
They have been considered whether they have accepted it or not. That
Right.
will come only when you say.
my lord, 2 weeks time may be granted, I'll file. My lord.
It will come along with. 5129. What's your good name?
I'm Chakravarti, madam.
What is it? Just submitted by. After the screening process. After it. Okay. The other cases of from Chipsagar are fixed for on 8th of August,
My lord,
and the affidavit to be filed by 4th of August.
my lord,
Same
I'll
order will
file. My lord, I'll file.
where Mr. Second. PN Sharma appeared in other matters.
My lord, item number 4, my lord.
List language. Yes, ma'am.
May please your lordship. My lord, it's very limited prayer I am before your lordship, my lord. Here, my lord, petitioner was a, my lord, master role employee, and he was he was, my lord, released from service on 31/5/2017, my lord. But his retirement date is 1/10/2017, my lord. And my limited prayer is that, my lord, for that period, my lord, my salary may be released, my lord. That is my very limited prayer, my lord.
Yes.
My lord, I'm appearing on behalf of Ms. MD Bora, my lord, for the transport department. My lord, the petitioners, we have filed our affidavit, my lord. As per the documents submitted, my lord may refer to paragraph number 9 of the affidavit in opposition. It says, my lord, if I may read, that with regards to para 6 of the writ petition, the deponent begs to state that as per the executive engineer IWD division Dibrugarh, the age of the petitioner is 17 years on 1st March 1971, and as per standard form of application, hence his date of birth is 1/3/1954. Subsequently, his retirement date will be 31/3/2014, but he was released from service on 31/5/2017 by order number such and such. The petitioner is claiming his age by through an affidavit that has been annexed as annexure 3 of the writ petition, which he has said that as per his horoscope, his age should his date of birth should be 1/10/97. Whereas the department's records show as 1/3/94. My lord, we see the last order. My lord, Ms. Andrivora was directed to take instructions on when the charge letter was received by the petitioner.
Yes, on that, your lordship
We have
may go
received
through the
instructions.
Annexa 4, madam.
We have received instructions, my lord.
No?
No, I have to repeat to you. 1/11/7.
service of the petitioner was regularized in terms of that division bench judgment?
No, no.
Or he remained in the
No,
MRO?
Prior
my
to
lord.
that, my lord,
They
he
have
was
been
released.
only working as master roll workers. my lord.
Master enrolled. Prior to that doesn't matter, he was released from service. And your lordship may turn to page 17 annex 4, my lord. That is his release order, my lord. It says, my lord, on 2/6/2017, his release order. Sri Gauri Shankar Bhattacharya, master roll worker of so-and-so from service under IWT subdivision Jorhat is completed government duty on dated 31/5/2017. So you are hereby released from government duty, and this communication the petitioner received on 1/11/2017, my lord. So my limited period is that, my lord, up to that period, my lord, since I am working, my lord.
You
My-
have given your admit card.
Oh, yes.
Now, see, on the basis of the admit card, your date of birth is was of 1st of March 1954. Now, once it is recorded in the Secondary Education Board of Seva, by filing an affidavit, can you change it?
So that's why, my lord, my limited period is that, my lord, if your lordship go through this annex 4, my lord, I was released on, this order is 2/6/2017, and the petitioner received a copy on 1/11/2017, and till then he served the department, my lord. So my limited period is that, my lord, your lordship may give a direction for release payment of that 5 months only, my lord. That is my limited period before lordship, my lord.
What do you have to say about this particular order number 99?
My lord, we have received instructions, my lord, that it was initially received by the petitioner on 2/6/2017, and then the memo letter was received later, my lord. My lord.
There is a question. It will take time. Take a look at this one.
That means you have served this particular order petitioner while he is in service on 6th of November 2017.
My lord, we had served it prior to his date of retirement, my lord.
How do
My lord, the memo mentions, my lord, that it was received on
1/11/2017?
my lord. I don't have a second copy, my lord.
This is what is my instruction, my lord. 1/11/17.
My lord, if I may take some time to verify this record, my lord, because here it's in the records it says, my lord, that he was performing his duty till 31/5/17 and released from his service on dated 31/5/17. Wide office order number 99 and memo number such and such.
dated 2617, my lord. If I may take instructions, it may be take some non-reading on that point.
See, you have released it. Why should you have filed it? Only after receipt of that letter on 11/2015. You might have issued the order that the law is well settled. You may pass an order, right? But unless you served upon the person, it's not communicated, right? This order is your official order.
Well, it might be so that we had passed it, but the receipt was, we had already sent it.
That's right.
Communication was done on our
It
part.
may be in your office, it may be in your file,
Hello.
but may not be communicated to the petitioner.
Hello.
What we have seen is that petitioner has received only on 1st of November 2017.
Hello.
That means up to 30th of October, he was working.
Hello. Hello. It might, I'm just supposing that might be that we had sent the letter. From our end, the communication was completed, but it was received on a later date. To the petitioner, my lord.
How to prove it?
My lord, I understand, my lord. My lord, otherwise, my lord, if
That is why the apex could have laid down the law very well. If you pass an order, if you put it in the file, not
Well,
about the passing of an order.
otherwise,
It has to be communicated to the person concerned.
my lord.
If it is communicated, then on.
Hello.
There may be various such orders you can find in the office file.
My lord.
But without being communicated,
True, my lord.
by which order you have communicated? Where is the number, communication number, either in the beyond or if you have been attending, you have the attendance register. You have been accepting his service. Right?
There will be some
Things
reports.
are all like that.
My lord.
When?
My lord, 2 weeks, my lord.
No. These matters cannot be 2018 matters. Okay. Today is 19.
My lord.
Maybe
You
on
will have it
Friday.
on
It may be on Friday, my lord.
1st of August.
My lord.
Give him something. Unless you show that it was duly served, that will not. Your good name?
RB Goswami, my lord. For Miss ND Bora. I give it. Obliged.
Yes, now you are ready.
My lord,
The petitioner has joined after this scrutiny and screening. What do you have to say, Mr. Das?
my lord, what happened, my lord, in this case, my lord, the department has filed an additional affidavit.
Saying what?
Saying that, my lord, my service has already been regularized, my lord. But that communication we have not received, my lord. And on last occasion, my lord, we were directed to obtain instruction regarding our
Then what happened?
regularization.
Then whether you receive instruction or not?
But my lord, my client, my lord, could not obtain any order, my lord, regarding her, my lord, regularization. And as per my lord affidavit, my service was regularized, filed order dated 27/2/2020, with effect from 27/5/2020.
এইমাত্র প্রিন্টার
Otherwise, my lord, impugn order is at page 85, my lord. I subsequent paper.
Yes, Mr. Das.
My lord.
Come to page number 36.
My lord.
Where is your selection before appointment?
My lord, what happened? Initially, I was appointed by managing committee in the Pensa school, my lord. And thereafter, my lord, in the year 1990, and under the centrally sponsored scheme, 500 posts were created by the state government. And one post was allotted to that Pensa school, my lord, Corvette Girls High School. And against that post, I was accommodated. Subsequently, that my lord scheme has been withdrawn. In the year 1998, my lord, screening test was conducted by the department, my lord, and all the my lord existing teachers, 500 teachers, appeared before the committee, my lord, and being successful, they were again accommodated, my lord, creating 401 numbers of total Hindi post of Hindi teachers, my lord, and accordingly, I was again appointed against
that
one of the posts. My lord, that is my lord.
Page 42.
My lord. Yes, my lord. 42.
Then
Thereafter, my lord, all those 401 numbers of posts were permanently retained in the year 2004, my lord. That is my lord, page 44, annexure 11. And my post was at serial 146, my lord.
that's right.
And but my lord, there was my lord discrimination among those teachers, my lord, because 82 teachers were accommodated in the Pensa school, and they were allowed only fixed scale of pay. And my lord, remaining 319 numbers of posts were accommodated in the provincial school, and accordingly they were allowed, my lord, regular scale of pay. Being aggrieved, my lord, some of the my lord Hindi teachers approached this honorable court in the year 2005, and this honorable court directed to consider the case of the petitioners, my lord. Accordingly, in the year 2007, my lord, an order has been passed, my lord. That is at page 52, my lord. Thereby, my lord, the claim of those Hindi teachers were, my lord, rejected. But considering the case, my lord, that they were not, they have no choice of their own to, my lord, for appointment in the Pensa school, my lord, decision, it was advised to adjust them in future vacant posts, my lord. And accordingly, all the other 76 numbers of teachers were adjusted. But, my lord, in the year 2006, I was transferred to a, my lord, provincial school. And from the Pensa school, my lord.
How you can be transferred?
My lord, that was, my lord, irregular. And that is why, yes, my lord. And since
First
then,
of all, the posts were created. See, everything has a little kind of background. The Hindi teachers' post was to provide or popularize the subject Hindi.
my lord,
The state of
my lord,
and posts were created
my lord,
under a particular scheme.
my lord.
And to teach Hindi in non-government school.
My lord.
And accordingly, a post was allotted in this Corvette. That was non-government. Wherein, as you are the Hindi teacher, you got the pick. Right?
My lord.
But the reported judgment in CLR and LT, I'm not getting the nickname, was very, very interesting. There, similar thing. Science teacher. Science teacher or something. They were appointed in all these ventures, non-government. Then posts were abolished. Similarly, they approached it for direct. The whole secondary school rules will be not have. They're all new. whole secondary education rules in seniority issue is there. There their appointments are formed. That's the error.
This aspect has already been considered by this honorable court in my earlier petition, my lord.
What happened?
My lord,
What happened thereafter?
my lord, this honorable court, after considering all aspect, my lord, directed the government to pass a speaking order as regard my regularization or adjustment, my lord. And thereafter, my lord, impugn order, that is case 85, has been passed, rejecting my claim only on the ground that I am having no TAT, my lord, for my accommodation.
Yes, then.
Then, my lord, in the meantime,
But
by
this transfer was at your own request. Not
yes,
because
yes,
of
my
the
lord.
public
Yes, my lord.
exigencies.
Yes, my lord.
Okay.
That is in admitted position, my lord, and that transfer was irregular. That is why, my lord, I am not getting the salary since the month of August 2006, my lord, till today, my lord. And but I am rendering service in that school till today against that sanction vacant post, my lord.
Then what happened?
Now, thereafter, my lord, in the earlier, my lord, writ petition, my claim for current and arrear salary was, my lord, rejected. And thereafter, my lord, I have approached the honorable division bench of this honorable court, and the division bench had order dated, my lord, 25/1/2018, page 88, my lord, started, allowed the current and arrear salary, my lord, and directed to pay within
Where
4
is
months.
that order?
That is, my lord, started from page 88.
No. Then
Meanwhile, my lord, the impugn order has been passed, rejecting my lord adjustment or regularization, my lord. And this,
no, the division bench judgment is where?
my lord, page 88, my lord. From my lord, page 87, it started. Relevant portion, my lord, operative portion at page 90.
That amount was paid to you.
No, my lord, not till today, my lord. And in the meantime, my lord, impugn order has been passed and liberty was granted by the division bench to approach this honorable court to challenge the claim, my lord.
Where is the transfer? 56.
56, my lord.
So you have not been paid salary from which date?
My lord, from August 2006, my lord.
Now, as per the finding of the revision bench,
My lord, we will get only from, my lord, 2010, my lord. Prior to filing of, 3 years prior to filing of the earlier writ petition, my lord.
so you will get it from 1st of July
My lord, 1st of July
2010
2010, my lord.
to when was the order passed by the government on 9th of January?
My lord. 9th of January 2000,
So up to 9th of January, you will get
24th of January 2017.
24th of January. Right. Yes, Mr. Khatani.
We have filed 2 affidavits, my lord.
No, whether the payment of salary was made to the petitioner.
As per our affidavit, my lord, we have in the additional affidavit we have filed it on, my lord, 3/8/2008. Date of filing, my lord, 13/3/2023, my lord. Here at page 14.
What is the finding?
Accordingly, headmaster of the said school draw and disburse her provisional monthly salary with effect from 27/5/2022 to 31/10/2020 and applied for release of first salary in the
Where you are really?
we have filed
Additional affidavit whose
paragraph 5, my lord. Paragraph 5, page 4, my lord.
That is not the direction of the court. See, please come to page number.
Yes, my lord. Page number
Come to page number 85.
85.
Now, if you come to page number 86,
Yes, my lord.
the Commissioner Secretary disposed of the appeal of the dispose of the appeal of the petitioner by the speaking order which was under challenge.
Yes, my lord.
Now, please come to 87, 89.
Yes.
Second para.
As agreed to by the council of the parties, we proceed to decide this appeal only on the issue whether the appellant is entitled to salary remuneration for the period during which she has been discharging duties as teacher. We are not deciding on the issue of regularization adjustment, which on direction of the court in the related WPC number so and so has been considered by the state respondent and decided against the appellant by apposite communication that so and so. Insofar as this communication is concerned, the appellant will be at liberty to assail the same in an appropriate proceeding before the appropriate forum.
Come to next.
It is seen that the appellant was appointed as Hindi teacher, senior on ad hoc basis at Borveti Girls High School under centrally sponsored scheme. She was appointed at a fixed pay of ₹1375 per month, and at the relevant time, that is in the year 1995, this said school was not provincialized. In course of time, her appointment was adjusted against post created in the same school by government letter dated 12/10/1999, followed by the order of the Director of Secondary Education dated 12/7/2000. In the year 2006, the appellant was transferred from Borveti High School to Polastol Kasomari High School.
Not provincialized to such and such.
Yes, madam, provincialized. On her
On her
own
own
request,
request.
against the sanctioned vacant post of Hindi teacher, which fell vacant vice one Sri Probin Chandra Deka, who had been transferred out from the seat from the school. From the time the appellant was transferred from the non-provincial school to the provincial high school, despite against the sanctioned vacant post, no monthly salary was given to her. This was one of the primary grievances raised in the related writ petition, but which did not find favor of the learned single judge. Facts not in dispute are that appellant was transferred to Polastol Kasomari High School against the sanctioned vacant post of Hindi teacher. On and from the date of her transfer dated 2/8/2006, she has been rendering her service in the said high school without any late or hindrance. There has been no cessation of her service as a teacher until today, and the respondents have not only allowed her to work, but have also utilized her service. The appellant has undoubtedly earned her salary for the period as she has been in service at Polastol Kasomari High School. Claim for salary is not based on part, but on the principle of quantum merit. As in service jurisprudence, it is not implicit that a person serves under the government ex gratia or that his salary is in the nature of a bounty. On the above facts and principles, payment of salary, arrear, and current as admissible under the relevant rules cannot be denied to the appellant. Having held as above, a caveat is expressed that the appellant's right to recover arrear salary cannot run prior to a period of 3 years from the date of filing of the related petition, that is so and so, which was filed on 1/7/2013. This view of our finds support from the judgment of coordinate bench in Harendra Chandra Nath versus State of Tripura and others. This writ appeal thus stands accordingly disposed of by directing the state respondents to pay salary remuneration to the appellants at admissible under the rules from the period commencing 3 years prior to the institution of the WPC number so and so, which was filed on so and so, with an outer limit period of 4 months from today. As regards the issue of regularization of service, which is now impeded by the communication dated 24/1/2017 as referred to above, liberty is granted to the appellant to seal the same in an appropriate proceeding before the appropriate forum.
So in terms of this order,
Yes, madam.
the petitioner is entitled for salary.
Yes, arrear and current.
It cannot be regular salary. It has to be the fixed pay salary.
Yes, madam.
Right? From the writ petition was filed on 1/7/2013. So from
3 years prior.
1/7/2010.
Yes.
The petitioner will be entitled for her salary.
Yes, madam.
And if she was found serving in that particular school continuously till the date of her regularization, her service has been regularized in the transferred school only.
Yes, madam.
So till then she has to be paid in terms of this division bench. This has not been paid because in your additional affidavit you say
Yes, madam, that has not been paid, madam.
from 27/5/2020.
The proposal, in fact, in the affidavit, we have stated that the inspector of school has submitted the proposal, but that was not acted upon.
Has to be because of division bench.
Yes, 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 madam.
See, the petitioner was, her transfer was at her own request. That could have been withdrawn by the
Authority.
inspector of school.
Yes.
It was not withdrawn. That could have been withdrawn and she could have been reverted back to her own. And thing is this, as it was not done, but the court, the division bench have considered that aspect of it. You have to pay.
Yes.
But Mr. Ikeda's learned counsel appearing for the petitioner. And Mr. N.J. Khatane, standing counsel, elementary education. Department of School Education, Limbecket Element. For the respondent numbers 1, 2, 3, 1, 2, and 3. And Mr. P. Gogoi, Pending council finance for the respondent number 5. Honorable Division Bench by its judgment and order dated 25/01/2000, number 19/2017, arising out of judgment and order dated 01/08/2016, passed in WPC number 3779/2018, referred by the present petitioner. Specifically directed the respondent authorities to pay salary oblique remuneration to the present petitioner as admissible under the rules from the period commencing with numerical utility of the 3 years prior to the institution of WPC number 3779/2013, was filed on 01/07/2013 within a period of 4 months. It is to be noted herein that petitioner was earlier appointed as a Hindi teacher under a centrally sponsored scheme on a fixed pay. Of rupees 1375 per month in the year 1995. Later, the service of the petitioner was adjusted against post created by the state government. About a sentence. At Borveti Girls High School under central for the rupees 1375. Venture Education Institute at the relevant point of time. Later, the state government, by creating post, adjusted her service on a fixed pay. In the same school at Borveti Girls High School. This time your salary was enhanced, I think so, from 1375 to something. Where is the order?
Is 42, my lord. $3580 per month. 3580 per month.
3580 per month. Later, at the request of the petitioner, the Inspector of Schools, Nagaon, transferred the petitioner from Borveti Girls High School, a non-provincialized high school, to and posted her at against a vacant sanction post at Palasachapal, Kaspamari High School, provincialized secondary school. In the graduate scale of pay against a vacant post 4 that will vacant due to transfer of one Provin Chandra Dekka Hindi teacher. The respondents in the elementary education, the director of elementary education, secondary education, by filing an additional affidavit on 13/03/2023, clarified that the service of the petitioner has already been regularized and regularized as a Hindi teacher in PALAS HPL, Kasamari High School, District Nagaon, by the order dated 27/02/2020, with effect from 27/05/2020, and accordingly, the petitioner was paid her salary with effect from 27/05/2020.
My lord, I have not received any salary after regularization.
Where is the order of regularization?
Order of regulation. I have submitted. It is not annexed to the affidavit, my lord. I have submitted a copy of the order, my lord.
You have not received salary?
No, my lord.
What was the finding in 1676 of the court? 1676/2006.
Page 51, my lord. 1676/2005, page 51, my lord.
In terms of that, my lord, direction, order dated 11/4/2007 has been passed. That is at page 52.
Okay, that's already one thing. We'll pass a detail order after some. Mr. Das, there is a judgment. uh, Equally placed. Same benefit should be given.
My lord.
Equally placed. Same benefit should be given. Find out that.
My lord,
Give us at 2 o'clock.
my lord,
Same benefit should be given.
my lord,
There is equally placed.
I did another order of this honorable court, my lord, that is passed in WPC number 6279/2012. The discrimination made among the teachers, my lord, appointed in provincial high school and fancy school has been held illegal, man.
Give us that order.
That has been annexed.
No, but equally placed.
No.
That is given. Mr. Khataniar, see, in that particular order, the education department came to the finding very well that some were appointed in Venture School, some were appointed in provincial high school. But those were appointed in provincial, but those were appointed in Venture School, they are appointed by chance.
Yes.
Right? And their services need to be regularized.
Yes.
Some of the teachers who have been appointed in the provincial high school, they are drawing fixed pay, but serving against
Sanction post.
That is the clear finding of the education department.
Yes, madam.
With regard to the judgment passed in 1670.
Yes, madam.
There they found only with regard to the petitioners. Right? It is not that petitioner did not approach.
Yes.
She is similarly placed.
Otherwise,
In fact,
only thing will be because of her transfer from a non-provincial to
now
provincial school.
the court have already said
Yes, madam.
the period 2006 will not come.
Yes, madam.
Though at her own request,
Yes.
because the deputy inspector, sorry, the inspector of school had no right to give that
Yes, madam.
finding that she was on a fixed pay unless her service has been regularized,
Yes, madam.
which the inspector of schools could not have done.
Yes, madam.
Now, right, whatever happened, she has been serving in a sanction post, but for that period, 1/7/2010,
10.
till the date of her regularization, now you have to pay her that salary, fixed pay. And from the date of regularization, she will be entitled for. Find out that. Please take your seat, Mr. Das.
My lord,
Where
the,
is that order? Where is that?
my lord, the judgment, my lord, passed in 6 to 7. That is, my lord, case 92. Relevant portion is at 110.
You are not a party in that case.
No, my lord. Since they were already regularized, my lord, they have already been adjusted, my lord. 2 cases were there, my lord, and that those cases have been disposed of by common judgment. Later on, my lord, review petition was filed. That has also been disposed of, dismissed, my lord, and benefit has already been allowed to the petitioners of that writ petition.
Yes, you got that as
My lord,
equal relief.
equal, my lord, that is a long judgment, my lord. State of Punjab versus Jagjit Singh, my lord.
Citation.
Reported in, my lord, 2017, 1 SCC, 148.
11 para.
Relevant, my lord, paragraph 42 and 60, my lord.
1660.
60. Here, my lord,
Just
there are 17 numbers of subpara in 42, my lord, and I am relying upon 42.3 and 42.1.
you're relying on 42.3.
My lord. (42.9) is also, my lord, relevant.
That matter relates to parity in pay.
My lord.
Mr. Khatanier,
And we are in similar footing. 82 numbers of T-shirts are in similar footing that has already been held by this honorable court. my lord.
By Supreme Court.
No, my lord, by this honorable court. That is, my lord, the judgment dated 6/3/2017, passed in WBC number 6279/2012. After discussing entire facts and law, my lord, in paragraph 16, page 110, it is held, my lord. And this decision has already attained finality, my lord. In terms of this judgment, my lord, the government has already allowed the benefit to the my lord, other T-shirt, giving retrospective effect.
Yes, Mr. Katani.
Yes, madam.
See, few things you have to see. Admittedly, petitioner was among those 82.
Yes, my lord.
Out of that, when the government initiated the process for those 82, they found 76 serving
In the same school, my lord.
serving in venture education
Yes, my lord.
and who are considered terms of government institution for regulation.
Yes.
But the petitioner, at her request, she made a request for her transfer to a vacant function,
Yes.
which was accepted. For that, you cannot punish the petition.
Yes, my lord.
It has been accepted by the district
Authority, my lord.
and accordingly it was posted again, valid sanction, transferred to them. Why? The reason was her service was regularized, right?
Yes.
And that place was a sanction post, but in a fixed place.
Yes.
Those persons out of 409, right? They were 401.
401, my lord.
401 or 500. Leaving aside 82, they were placed in the provincialized secondary.
Yes, my lord.
They got irregular. But those persons out of 401, 300, 309,
90.
so they were similarly placed with the petition. Another group of that 80.
Yes.
Now, to see, after this order of 2017, this is under challenge.
Yes, yes, sir. Page 85 order
The division bench have already passed an order
for payment
regarding
of
the payment
area and current salary.
effect from 2007.
2010, 2010.
On 7, 2010. That order has not been complied. Now, if you see the affidavit of the director,
Yes.
first affidavit filed on 10th of November 2022.
Yes, ma'am. Paragraph 4 and 5.
Before that, come to, there are two Roman 12.
Yes. Yes, madam.
Those 6 teachers which are left out were also carried. So that means what?
Yes, madam. In the
That
meantime, verification.
indicates- Right. Now, come to the second affidavit. There are 3.
Yes, madam.
The bold portion.
After the area proposal of the petitioner forwarded to government by this office letter number so and so dated 27/12/2021.
Not acted up
Not acted.
by the government.
Yes, madam.
Now come to para 5 later part.
Accordingly, the proposal for first salary of Srimati Beauty Deka submitted to the government in Fin Assam portal bearing proposal number so and so from this directorate for approval. But government raised objection as there is no specific order from the honorable court for regularization of the service of the petitioner Srimati Beauty Deka as Hindi teachers at so and so school Nagaon.
But the director has already
Regularized
considered the
the service.
matter, forward a proposal
Yes,
for
madam.
regularization of her service.
Yes, madam.
Mr. Gogoi is not here. We will not say anything about because that part has been left. That has not been considered by the division bench. So
Yeah.
we will not go beyond the division.
Yes, madam.
So from 2006 onwards, from the date of her joining the present school where she has been regularized. Till 1/7/2010.
Yes.
That is till 30th of
June 2010.
regarding her salary will not say.
Yes, madam.
But from 1/7/2010.
1/7/2010 till the date of judgment, my lord, by the division bench. She's
Not the
other.
date of judgment.
No, I am saying that she's the division held to be she's entitled.
No.
Thereafter, she is also continuing.
Not that. See, division bench has very specifically stated.
Yes, my lord. Area and
Current salary.
yes, my lord.
So current salary is still her
Yes, my lord.
regularization.
That's what I'm saying. Look, after that also she was continuing. In fact, we have admitted in our affidavit that she was continuing.
What's that out?
Yes, my lord.
Right? Because certain facts have to be written, it will be too long.
Yes, my lord.
Consider. We will set aside that order of the commissioner regarding requirement of
TET, my lord.
state.
Yes, my lord. That is the only reason that our case was rejected.
It was not her fault
Yes, my lord.
for her transfer from the particular school.
And my lord, the salary was not released because there is no specific order from this honorable court to regularize her service. That is why salary was held up by the government, my lord.
Inform because since finance department is also party here.
Yes, sir.
Direct for the education.
Yes, sir.
Right? It's also panel.
Obliged.
In this case, my lord, we have to file our affidavit here, my lord. Two petitioners were there. One has already appointed and he has accepted it, my lord. And other one is not joining service, my lord.
Your affidavit, that's like a similar of that of
My lord, my lord.
Sibsagar matter.
My lord, on 4,
You
8,
file
I'll
an
file.
affidavit on 4,
4, I'll file.
no representation on behalf of the petitioner on 4. So name of the council. Art Mr. For an setting of the department for the response. 1, 3, 4, 5, 6, and Mr. P. Gopati on the finance for the respondent of. In other case, we have finance is a party we have directed. The order is the item number 6. Correct.
In item number 12, we are also going to file affidavit, my lord. Here, my lord, petitioner has accepted the my lord, appointment.
So 1, 3, 4, 5, 6. stepping forward.
Obliged, sir.
My lord, in this case, my lord, I am appearing on behalf of my lord P.J. Soikia, my lord. My lord, he is my lord in index, my lord. My lord, in this case, my lord, the similar matter, my lord, already, my lord, Justice, my lord, Devasis Bora, my lord, dismissed the repetition, my lord, and my lord, the repetitioner, my lord, Helen, my lord, filed a writ appeal, my lord. One of the writ appeal, my lord, the number, my lord, 156 of 2023, my lord.
Just issue involved in this petition has already been decided.
Lordship. Lordship.
That was in favor of the petitioner or against the
Against the petition.
Against the petitioner.
Yes.
Do you have that number?
Yes, Lordship. It is writ appeal number 156.
No, the concerned writ petition, the judgment in order will under
That is my only my the petitioner's name, and one of the petitioner's name, my lord, Purnima Harmal. My lord, late my lord, he is my lord, and late my lord, Purnima Hara, my lord. Purnima Hara, my lord, H-A-R-A.
Mara. What is the writ appeal number?
Writ appeal number, my lord, 156 of 2023.
WPC number 6403 of 2021.
6403.
My lord.
2021.
My lord.
Dispose of on? Any idea?
We'll
get it. You said 156 of 2022.
23, lord.
One 156.
Lordship.
Some Deepak Taluk.
Maybe one of the petitioners.
Well, there, my lord, is a bunch of writ petition, my lord. But maybe, my lord, one of the writ petitioner, my lord.
Date of judgment 31st March.
Just a minute. Civil road. Writ petition.
Writ petition, ma'am.
Because the common judgment, there has to be a common judgment. Because the other cases is not been.
That is Purnima Horo, my lord, WPC number, my lord, that is judgment dated, my lord, 31st March 2023, my lord.
It's not loaded here.
WPC number 6403/2021. If my lord, it is covered by my lord, Purnima Horo.
Purnima Horo and another.
My lord. 6403. Here, my lord, regarding only stipend teachers were, my lord, allowed to able to, my lord, get the pensionary benefit. Other OBB and, my lord, OBBs were not entitled to get the, my lord, pensionary benefit as per all pension scheme. As per this judgment, my lord.
Which OBB?
Operation Blackboard, who are appointed under the OBB scheme, my lord.
There are two OBBs. 2776 or 4040.
2776 probably.
Laptop is going to Kali laptop. Forgot your name.
The Ellen Ning.
Counsel for the petition. And Mr. Bora, Standing Counsel, Department of School Education. For the respondent numbers. 1, 3, 5, and 6. As well as Mr. T. Gogoi, Standing Counsel Finance for the respondent number 2. Is submitted that this petition, the issue involved in this petition has been settled, has been decided by the coordinated bench of this court by common judgment in order dated 31/03/2023, first in WPC number 6403/2021. Purnima Horo or something like that.
Man.
Purnima Hore, HORE, and another and 3 others. Another connected person. Rejecting the claim of the similarly placed persons as that of against the same. Presently, read appeal number 156/2022, sorry, 2023. It's presently pending. Pending for the honorable. In view of the after the decision in 156, or you want that similar order to be filed?
After disposal of the
Read appeal. Registry shall list the matter according to immediately after disposal of writ appeal number 156 of 2020. It is also made clear that after disposal of the said writ appeal number 156, the petitioner shall also make mention with regard to the listing of this.
Bless. My lord, item number 26, my lord. My lord, the respondent file, my lord, affidavit, my lord. My lord, take time, my lord, for filing, my lord, reply, my lord. The transfer matter, my lord.
Only thing, my lord, is they already 2019 matter.
Just now just tell us, Mr. Dihina, transfer is for how many years?
My lord, the initial item number 26, my lord, petitioner was transferred, my lord, on 7/12/2019.
As per the rules,
3 years.
it is 3 years.
3 years. Okay.
In that case, probably this order has become infructuous.
My lord, what
This order was state.
Yes, sir.
Now, that was state, that was an transfer order of 12th of July 2019. Now, after the stay, the interim stay since
My lord, I have
9/8/2019.
I have annexed the subsequent order that.
So it has since 3 years period is over.
Yes.
Will not interfere now.
My lord,
That's not the law, you know.
My lord, there is a there are my lord, special my lord guidelines, my lord. My lord, petitioners, my lord, minor one is a special child. He's a mental
It
retarded.
doesn't matter. We'll make it clear. That period is already over, right? If any transfer is made, it will be fresh and new. A new cause of action will arise. In that case, you are always free to approach. There is nothing wrong on that. Since this period case is already over. Now, since 2018, 19 in fact, you are there at the Tezpur, I think so.
Yes, Lord.
So it has become infructuous.
And whatever his grievance, my lord, he may file a representation, my lord.
Now that grievance was with regard to that transfer.
Yes, my lord, but another represent file on the second one.
What happened, my lord? The earlier it is pending, my lord. During the pendency of the revision, my lord, the national authority, my lord, issued my subsequent transfer order, my lord.
When?
Without, my lord, the leave of this
That
court,
order will go. That order will go.
Yes.
Right. Where is that transfer order?
Second, my lord, item number 27, my lord.
Which page?
My lord, that is, my lord.
26/4/23, Lordship Annex 16.
Annex page, my
Can you
lord.
tell us the page number? Annex 16.
16, Lordship.
Page, my lord,
You got it, you got
86, my lord.
Where is that?
88 is a relevant page, my lord.
Serial number?
Serial number 969, my lord.
Well, that order also, my lord, kept in advance, my lord, because of this pendency of the earlier.
Necessarily disorder will
Yes,
go.
yes, my lord. We
This
understand.
order is without.
Yes,
taking
I
leave of
understand.
this,
Yes,
right?
my lord. It
Now,
kept in.
Mr. Medhi, can you show us the provisions for transfer?
Yes, sir. That is, my lord, the provision, my lord, page 9, annexure 17, my lord. Page 91, there is
17 in which repetition?
a second edition, 27. Page 95, my lord, kindly see, my lord.
In earlier, my lord, is 44. First one, revised transfer guidelines, SSB 44, first one.
Page 95, my lord, second one, my lord.
Video number
13, my lord, column 13, my lord. 1, 2, my lord. Disability of family members.
Where is the other provisions of transfer?
This, the first education manual is 44 manual is standard operating procedure manual, revised transfer guidelines. Same, this same manual.
Page 44.
The first manual. And this tenure manual in page 46 manual. Page 46 manual, first one manual. Normal tenure for posting areas classified by the so will as follows. ANO 22 years, high altitude areas 2 years, hard area 2 years, normal at 3 years. And the beside the classification tenure static formation 3 years, frontier 6 years, 2 normal tenure, 3 years each file sensor, 5 years.
What is NCR tenure?
My lord.
What do you mean by NCR tenure? That serial number 5 at page 46.
Yes, yes. I by NCR tenure.
What is NCR? Normal something?
Yes, sir. Well, he already, my lord, this my state more than my lord, from 2017 itself, my lord, he is there for test for my lord. 2017, my lord, 18, 19, 20, 21.
National Capital Region, Lord.
National capital, yes. Already, my lord, from
the transfer order of the petitioner to page 2. Transfer order of the petitioner to
transfer order. First one, my lord. First one,
my lord.
34A page, my lord. Page 34, my lord. In the first requisition, my lord. They have this relevant the type copy, my lord. Person 64, my lord. His name is there, my lord.
64 is serial number, my lord. Frontier test put to
When you have been posted at Tejpur?
My lord, from my lord, the 2019, my lord. I have, my lord, the
2017, my lord. He is mentioned. Yes. Okay, page 6, my lord, paragraph 3, my lord. Page 6, paragraph.
Referring for
In the second case, for the respondents.
in the second
Yes,
case you are
ma'am.
referring. In the
Yes.
first case you are referring.
Yes, ma'am.
Not Mr. Kalani. That comes referring for the petition. And I'm sorry. Learned CGC. For all the respondent numbers.
Oh, so my
Petitioner, please take your seat. Is the head constable within Better General Duty in the office of the Inspector General, Sashastra Sima Bhalpura, Frontier Headquarter Command in the district of Sonipur. By an office order number 04/SSB/NHC/P capital PE personnel PERS dash capital Roman 2 oblique 2019 oblique 10435 /545 dated 12/07/2019 issued by the commandant within bracket PERS personnel dash Roman 2 of the SSB, Government of India, Ministry of Home. Along with (580 employees of the SSB throughout the country, transferred the petitioner from FTR stands for what?
My lord,
FTR stands for what?
Frontier
headquarter. my lord.
Frontier Headquarter. Frontier Headquarter is good of it SSB. So Frontier Headquarter of the SSB at Siliguri. Minor son of the petitioner. Is suffering from hypoxic SYPOXIC ischemic ISCHAE-MIC injury. As such, petitioner filed connected rate petition WPC number 5755/2019 challenging his said transfer order from Jethpur to Siliguri in the SSB. The court by order dated 09/08/2019 while issuing notice in said application number 5755 state the transfer of the petitioner from Jethpur Frontier to Siliguri Frontier, which is still in during pendency of the said writ petition, the petitioner application number 5755 and the stay order, the That is 0908/2019 for incidents from SSB Frontier to here. Respondent authorities in the SSB again transfer the petition. Very impugn order number. Mr. They are taking public 18, public SSB, public personal PRS, public 80, public 202, public 11196, that 113. From Frontier Headquarters Case Court. 55 SSB. To where?
My lord, 55 battalion, my lord, is my lord Pithoragarh, my lord, Uttarakhand.
To Itanagar, right?
Uttarakhand.
Uttarakhand. Posted at 55th battalion.
Yes, sir.
From Frontier Headquarters Case Court, the SSB, to 55th battalion of the SSP at
Uttarakhand, Pithoragarh, Uttarakhand. Pithoragarh, my lord.
Uttarakhand. Without taking leave from the court. Being aggrieved, petitioner preferred to court. By an order dated 1606, by common order 1606, Austin set application number 5755. This order not in evidence. This order.
Lordship, I informed them that there is a stay in the previous case, so that is kept in abeyance. No action was taken in that.
Since the transfer order, impugn transfer. Issued by the commandant. Yeah. The authorities concerned in the kept the sale of this order, transferring the from Frontier. So the court by order dated 12/5/2023 directed the respondent authorities SSB as to how the impugn order dated 26/04/2023 could have been passed by the authority concerned. During dependency of connected applications The respondent parties did not submit any affidavit, neither submit any affidavit, not present any insufficient. No.
Notice was also not issued in this.
Not necessary. That specific observation of the court is there. It is seen that the order office order 326 transferring from SSB from here. Implement transfer order petition. Being not in conformity. It will go to the static part. Prior to that. Since when we are serving at this school?
My lord, as per his my lord, statement, paragraph 3, my lord, is 2017, my lord. Page 6, paragraph 3, my lord. Last line, my lord, last he was transferred from SHQ Bomdila to the headquarters Tezpur on 1/6/2017 under the compensation ground.
That is serving. They want to Very important. It's a competent medical. The petitioner was transferred from by order dated 12 July. By office order dated 12/07/2019.
From Tezpur frontier
Transferred
to
from
Siliguri.
headquarters at
Siliguri.
Headquarters. SSP frontier. Satisfied. Raising notice to respondents by order 09/08/2019 suspend. As for yes. The revised transfer guidelines of the Success Trust issued by the Personnel Directorate, Force Headquarters, SSB, dated 16/08/2016. It is seen that the tenure of the normal tenure of posting normal areas is 3 years, as provided at clause 5. Tenure of said revised transfer guidelines for the SSB issued on 10/08/2016. The
My lord, in the same guideline, my lord, kindly see, my lord,
clause 13,
page 52, my lord, column
Yes.
30.
clause 13.
It is subject to vacancy, madam. Administrative feasibility and tenure policy.
The standard operating procedure regarding revised transfer guidelines for the SSB personnel dated 10/08 provides as follows. that relates to disability of family. Mr. Dehingi, counsel for the petitioner also brought to the notice of the court that the Directorate General of the Solicitor Streamable, right number 1/58/SSB/PRFR/PERS, that's capital 15 record 2016/35 511-531 dated 10/02/2023 brought into force new transfer guideline for the SSB personnel and accordingly issued standard operating procedure of the transfer and posting of the employees the SSB. Wherein at clause 13 relating to disability of family members of the employees of the SSB, it's specified that page number 55, the second it is an admitted fact that the petitioner is at SSB Frontier headquarters at Hill School, District Sanitary since 1/6/2017. The head constable in bracket of the SSB. For more than 6 years. The impugned transfer order of the petitioner issued by the commandant within bracket person PRS -2 of the SSB dated 12/07/2019 is out more than 4 years. By as the minors are of the petition, they're suffering from medical ailments. Needless to say, in the event of transfer of the petitioner, from SSB Frontier headquarters, H4 to any other place of the SSB, will be entitled to apply as per the provisions of disability of family members specified in the standard operating procedure, 11 standard operating procedure pertaining to transfer guidelines for the SSB personnel in force. In the event of filing any such application by the petitioner under disability of family members on his transport, the authorities concerned in the assessment shall consider the same in accordance, giving an opportunity to hearing.
This time my lord filed my lord representation, my lord earlier.
Not at this stage. Why do you file it? Only when you'll be transferred.
Yes.
At that stage you can file application. Will be given an out hearing. That's all.
My lord, first representation, my lord,
All are closed.
close.
First one has become infructuous. That order will
Yes,
cannot sustain after
yes,
3 years.
yes,
no?
my lord. Second was my lord interference.
Second has been set
Interference.
aside
Yes,
because it was without taking leave of.
yes, yes, yeah.
But this is a common order, so it should be only for the petitioner there.
That is only for the petition. That we have considered. In Buddha matters, it is only for the
Yes,
petition.
madam, yes, yes.
Not for so many 500
Yes, yes,
persons.
Wait, please, your lordship. If your lordship pages the annexure 6 at page 26, the petitioner is claiming is unused, which are mentioned in the order, your lordship, at page 26.
As per my instruction, lordship, it was all paid, lordship. Hey, BPF, 62,000 into a slab, no? That is a 1290. It was. It will December, possible.
Then 80 a month.
Yeah, I will accept it.
Okay.
No. No, if I say passbook,
File an affidavit.
Lordship.
It is sufficient.
Lordship.
Right.
Only there's no mention of the substances allowance, your lordship, in this
Because
order,
it
your
has been
lordship.
stopped.
The reasons for stopping of substance.
Yes, your lordship.
Basically, to page number 22.
20, your lordship.
21.
Yes, your lordship.
Kindly read.
Barber uncle placed on the suspension remains present.
Provided remains present, your lordship.
Only when he is available.
Yes, your lordship. That's
he will be
mentioned in the
entitled
order.
for that amount.
Yes, your lordship.
What is the instruction that was all along he was available?
No, your lordship.
He was not. Mr. Roy?
Lordship. Your lordship may close the petition.
In terms of this, lordship may close the, keeping the instruction on record.
The petitioner will not know.
Lordship, he has filed an additional affidavit.
In
where
the additional affidavit, the bank passbook is being annexed, your lordship.
Annex, and here the amounts are reflected.
The amounts are reflected.
No, the reasons for withholding the substances.
That is not
will
that.
be
That
aware
is,
by the petitioner.
that is not been not made known to the petitioner, your lordship.
And Mr. S.S. Roy. Some.
1 to 5. 1, 2, 3, 4, and 5.
You are appearing for whom, Mr. Mehdi?
I am for my lord account 7. 7.
Finance, anyone is here? Or P. Gogoi? Standing Council 80. Petitioner. Barber in the 11th Assam Police Battalion, Belgaum. Because of his negligence of duty and indiscipline conduct, habitual visit, the Commandant of 11th Assam Police Battalion, Belgaum, by an order dated 18/12/2007, suspended the petitioner with effect from 17/12/2007, enabling him to draw substantial allowance as per rule during suspension period, with the observation that the petitioner to remain present at the concerned battalion headquarters, at the battalion headquarters, and attend roll call regularly. The petitioner subsequently discharged,
Was removed from service, your lordship.
removed from the service with effect from 22/08/2008. As per the finding of the departmental proceeding approved by the Commandant 11 Assam Police Battalion, Belgaum, on 22/08/2008, with the observation that he shall not get the benefit, any financial benefit except the substantial allowance for his suspension period, with effect from 17/12/2007 to 22/08/2008. Is entitled to get DIS and DPF as per. The petitioner preferred an appeal that was also dismissed by the concerned appellate authority, I, Deputy Inspector General of Police, in bracket TAP of the city, bracket close. Assam, account on 18/03. By filing an additional affidavit on 19/01/2023, the petitioner stated that he hasn't been paid the PF public, the PS oblique DIS and other service benefits after his removal from service. Order dated 22/08. Security. During the deliberation of the matter, Mr. Royal and Government Advocate Assam placed a communication dated 03/01/2022. The Commandant 11 Assam Police Department in their account regarding the payments made to the petitioner, including the subsistence allowance. During the period of the suspension, the final order 2020. The respondent authorities shall now place the same by way of an affidavit, enabling the petitioner to know the reasons, the amount that has been paid to him throughout the DIS and the certificate of service during the period of the order. Such affidavit shall be filed by the authorities in 11th of on or before 4th of August by serving a copy of the statement
Can it be on 7th of August?
placed on 10th of August.
Much obliged.
Please, your lordship. Lordship, the matter here pertains to bringing the petitioner under the old pension rules, lordship, along with the payment of arrears salary. Lordship, the department have not filed their affidavit yet, lordship.
Weeks time, 2 weeks time more time. No, nothing. No time. Instruction notice. Yes, what is your prayer here?
Lordship, in this petition, we have prayed for, regarding the condition, Lordship, there is a condition for bringing the petitioners under the new pension rules. It starts at page 92, the operative part, Lordship, the appointment orders. There is a clause regarding bringing the petition under the new pension rules. But my case is that since there was a delay caused in our appointment, we ought to have been appointed earlier. So we should be brought under the Assam Service Pension Rules 1969, Lordship. And the select list pursuant to which we are selected, some of the candidates below our names, they have been selected earlier, and because of that, they are getting the benefit of the old pension rules. But because the delay is caused in our appointment, and that's why we are brought under the new pension rules. Lordship. So my prayer is to bring us under the old pension rules. That is the main prayer here, Lordship. May I pray here, Lordship? Lordship is taking up the matter for final disposal. Lordship, I will take some time.
Finish now itself.
Lordship may grant me some time, Lordship. I'm not prepared to do.
There's nothing to prepare here.
Lordship may grant me 1 week time, Lordship. I'll come prepared. Affidavit has not been filed. That's why,
Not
Lordship.
required to fight.
Okay.
Everything is in the orders.
Lordship, there are certain things, Lordship, that needs to be looked into. Lordship may fix another date. I'll come prepared the matter, Lordship. Lordship may take up then for final disposal.
'27. Order hearing. Along with the records of WPC number 5985/2013, disposed of on 28/07/2016, as well as the writ appeal number 387/2016, which writ appeal number 355/2016, disposed of by common judgment in order dated 02/06/2017.
Much obliged, Lordship.
Where is finance? Finance was supposed to. Well,
Lordship, here I'm praying for one shot accommodation to file the affidavit, Lordship, because we have missed Lordship 3 weeks.
Mandate further time on 7th of December 2020.
Lordship, here we'll file it before the next date, my Lord. Lordship, one last opportunity may be given, my Lord.
Tell us when you.
Lordship, within, after 3 weeks, Lordship.
Ah. I was tentative on 7th of December.
Oh, Lordship, within 2 weeks we'll make it.
Placed on 3rd.
Third over, Lordship.
In the meanwhile, the respondent finance department shall file
Lordship.
their affidavit in terms of the order dated 07/12/2022
Lordship.
on or before 29/07/2022. Having a copy of the receipt.
Right, Lordship.
The petitioner is aggrieved by the act of the respondents in imposing a maintenance on him for his wife at the rate of 22% of his salary, despite the fact that the wife has already approached the family court, has been drawing her maintenance, and my lord, even their own procedures say that in the given circumstances that maintenance could not have been imposed upon me. And my lord,
Now, this maintenance is under 125? or
no,
under-
my lord, no. It is under certain SOPs issued by the respondents where they want to say that being a member of the force, a force personnel, he is obliged to maintain his wife whether there is a relationship between them or not, and further that can go up to 22% of the salary. If Lordship will kindly have the first report which has come, my lord.
Have you challenged that particular provision of the?
My lord, my challenge is that even if we go by the SOP, the conditions laid therein not being fulfilled and reports being in my favor, they could not have imposed the maintenance upon me. There are other judgments of this honorable command. It is a part of the Assam Rifle rules also, where there is a provision where they can impose a maintenance upon certain personnel to maintain the family. That power is there in the rule.
First provision.
My lord, the SOP Lordship will have their affidavit in opposition. Lordship would like to come to page 83, internal page 20 of the affidavit in opposition, running page 83.
83, I do not have 83. Anyway, which provision?
Lordship has?
Clause.
My lord, it starts with the first clause. Assam Rifle personnel subject to AR Act 2006 are legally and morally bound to maintain their legally wedded wives and
page what?
legitimate. My lord,
Internal page.
my lord, internal page is 20 that they show.
20, man.
Yeah, it's 19 here. Yes.
2 GB.
I'm sorry. All Assam Rifle persons subject to AR Act 2006 are legally and morally bound to maintain their legally wedded wives and legitimate illegitimate children, whether a harmonious relationship exists between them or not. There is a provision of penal deduction from the pay and allowances of officers under Assam Rifle Act 68 and from the pay of allowances of JCOs and other ranks under AR 69(1) towards maintenance of wife and legitimate and illegitimate children. This letter lays down the policy for effecting penal deductions from the pay and allowances of officers, JCOs, and other ranks of Assam Rifle towards maintenance of the wife and children. Then Lordship will find paragraph 4. These orders are applicable to all persons subject to AR Act 2006. Persons subject to Army Act on deputation from Army will be governed by Army Order 2 of 2001. These provisions do not apply to civil employees of Assam Rifle who can approach the court of law. Now, Lordship will come down below. Lordship may like to come down below procedure for processing maintenance cases. The procedure given in the succeeding paragraph will be followed scrupulously on receiving a request for maintenance and maintenance allowance. While acknowledging the wife's request, she will be asked to intimate by means of an affidavit whether she is employed, and if so, indicate her emoluments. She will be asked to intimate details of any independent source of income or movable or immovable property she may possess and any income therefrom. B. CPOAR will be asked to intimate the latest details of pay and allowances. C. Details of wife and children will be checked from the unique record. D. Each case will be processed on its merits, for which it will be imperative to ensure the following: the petitioner is the legally wedded wife of the person or his legitimate or illegitimate child. The person complained against is neglecting to maintain the petitioner. The wife is unable to maintain herself and dependent children. Having ascertained the above aspects, a show cause notice duly signed by the staff officer rank for and by the competent authority to sanction maintenance allowance after having obtained the formal approval of the latter will be served on the individual. Therefore, Lordship will have number F. Maintenance allowance may not be granted to wife and or children in case the petitioner has sufficient income means to maintain herself and the children. Therefore, in case where it is clearly established that the wife is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent, she should be advised to take recourse to a court of law and should not be normally granted maintenance allowance. The amount of maintenance allowance sanctioned will not exceed 33% of the pay and allowances and shall not be at a rate higher than the following: 22% of the pay and allowances in respect of wife. Then Lordship would like to have page, the
7.
if I'm allowed to.
Sorry.
Either he starts or I start.
Sorry.
Yes, next.
Lordship would like to have page 22 next.
Yes.
At the top, to make provision for payment of the areas for the maintenance allowance and maximum deduction of 50% from the pay and allowance of the individual for that month will be permissible. This is the policy that they want to follow. Now, Lordship will have the status of the petitioner. If Lordship would like to have page 48 of the repetition. The process that is to be followed, that I have understood from this office memorandum, is that once a complaint is received, there has to be an affidavit from the wife saying that she is not able to maintain herself, and thereafter the show cause notice to me and the further action is to be taken. Now, if Lordship would find at page 38, I'm sorry, my lord, the first show cause notice which comes to me is at page 23.
Yes, page 48.
My lord, page 23, my lord, page 23. is the first show cause notice given to me saying that my wife has claimed a maintenance. And Lordship will have the last paragraph. If no reply is submitted by within the stipulated period, it shall be presumed that you have no grounds to urge against the grant of maintenance allowance to your wife and a daughter. My lord, we are without children. We are without issues. This daughter has cropped up at page 23, the last line. The daughter part is a creation of the respondents. Now, my lord, in reply, I have given at page 24, where, my lord, I have said at paragraph 3 and paragraph 4 that it is because she wants to stay with her parents that she refuses to have my company. Having considered that, my lord, they pass an order. I'm sorry, my lord. In the meantime, the private respondent approaches the family court at page 31. Lordship will find the order passed by the family court at the relevant portion at page 34. It starts at page 31. And at page 34, Lordship will find the relief granted to the petitioner. In fact, this was in a divorce case filed by me. The original case number being 336 of 16. She filed an application, and at page 34, it said the prayer made by applicant Srimati so-and-so under section 24, the Hindu marriages is partially accepted. Opposite party is directed to pay the applicant amount of rupees 5,000 as fees of an advocate, as rupees so-and-so expenses per day for traveling expenses, and rupees 4,000 per month as maintenance till disposal of the case. Thereafter, the respondents issue a letter on page 38, where they, on 10th of September 2017, in exercise of the power conferred under section 69(1) of the Assam Rifles Act, sanction is hereby accorded to the deduction of maintenance allowance at 22%. At page 41, they refer to the case, maintenance case, which was filed by the wife, and thereafter they say that it will now resume with effect from the month of January 2020 onwards, because in the interim portion, she was only entitled to what the Honorable Court had directed. Lordship will find the last paragraph. The grant of maintenance allowance at 22% and allowances sanctioned by so-and-so will be resumed with effect from 10th of January 2020 onwards. I make an application, my lord, and in that application, Lordship will find a communication at page 48, which is given by my unit commander to the higher authorities at page 48. Original Lordship would find at page 51. This is the translated version. This is given to the Directorate General saying, para number 2, Srimati so-and-so, wife of Mukesh Kumar, were hereby informed earlier through letter to stay with your husband in official quarter and sort out the differences. The said facts have also been informed to the headquarter. An official quarter has been allotted to Sri so-and-so, and he has also expressed his interest to maintain a happy married life. To this effect, several communication has been made to so-and-so for her confirmation, but she has not responded to it. Page 49, para 3. Apart from that, by letter number so-and-so, Headquarter Assam Rifle East IGR Establishment Administration informed the pay and bill section of his Assam Rifle to deduct monthly maintenance allowance from pay and allowances of rifleman so-and-so, and to pay monthly maintenance amount to Sri so-and-so. Further directed this office to take confirmation letter from Mrs. so-and-so regarding receipt of her monthly maintenance allowance. From this effect, several communication has been made to so-and-so regarding receipt of maintenance allowance, but she has not responded. Moreover, as per policy as forwarded by you, clause 9G of paragraph 1K, it is clearly noted down that if the wife is in adultery or separated from husband without any cause, or separated with mutual understanding, then ask her to approach the Honorable Court and not entitled for maintenance even in minimum amount. Though several communication has been made to the wife of petitioner with a request to stay with her husband in official quarter, but she has not responded till yet. On the other hand, rifleman expressed his interest to stay with the wife in official quarter. If any misunderstanding took place, same shall be sorted out. Despite effort from Sri Mukesh Kumar, her wife has not shown any interest to stay with him in official quarter, and his resident rather stay to prefer in her maternal home. From the aforesaid fact, it has become clear that the said case is one-sided. For the reasons
aforesaid reasons, day by day, Munesh Kumar has lost his mental stability and could not concentrate his duty. In such circumstances, it would be proper to stay the order of maintenance as per policy letter forwarded by you incorporating clause 1K so that force personnel can get justice. This lordship will see is issued by Yogendra Kumar, Captain and Adjutant Deputy Commandant. This is forwarded by him to the higher officials. Again at page 53, Lordship will find that there is another communication of 21st of July. Communication has been made by this office by above letter to propose stay order of maintenance allowance to Srimati so-and-so, but no communication has been received from headquarters. Therefore, it has been prayed to communicate headquarters so that forced person can get justice since the case is one-sided. It will be proper to stay the order of maintenance till decide the issue in presence of both parties. Forced person is mentally disturbed day to day and also to discharge his duties, communicate the same forthwith. Normally, when they continue at page 55, Lordship will find out of my total salary. I'm sorry, my lord, at page and on the next page, my lord, page 57. At page 57, Lordship will find down below total dues is 52,495. My net pay is 46,882. My cash recovery is 17,472. This, my lord, continues on the next page also, page 58 also. The total deduction for that month came for 25,000. On the next month, my lord, the total deduction comes to 32,000. Now, they have filed an affidavit, my lord, where they have not referred or answered to the issues that my commandant, my captain has been repeatedly informing them that this is a one-sided case. She has a maintenance case which is already there before the honorable court, which is given a decision that she will be entitled to a maintenance of 4,000. Without answering that topic, they have only referred to the power conferred upon them by the policy to say that we can deduct that 22% and pay it to the wife. Now, there have been earlier judgments of this honorable court, my lord, where it has been held by this honorable court that maintenance is a issue which will be dealt with by the appropriate court under section 125 CRPC. Lordship will have their affidavit in opposition at page 69, my lord. I'm sorry, my lord. At page 70, para 4. Page 70, para 4. They admit that I have informed them that she is a teacher and she has her own source of income. She is living away from me, which has been supported by the letters of the commandant. And for their own policy, they were required to ask for an affidavit from the wife regarding her ability to sustain herself or maintain herself, which, my lord, has not been done in this present case. They have simply awarded that maintenance without following the process laid down by the SOP itself. In such a situation, my lord, in my humble submission, when something is done to be is required to be done in a particular manner, and that manner is not followed, the entire order has to go. Lordship will find at the SOP which they have annexed on receipt of the complaint at page 83, my lord, internal page 19 of the affidavit in opposition. While acknowledging the wife's request, she shall be asked to intimate by means of an affidavit whether she is employed, and if so, indicate her emoluments. It is only after that a show cause notice could have been given to me. And it is not the stand of the respondents that that affidavit was ever called for. Moreover, the entire issue being under the entire issue of maintenance being already agitated in an appropriate forum of law, which awarded her an interim maintenance of 4,000 till disposal of the case. This imposition of this,
that matter, main case is first time because
my lord, that order, so far as I have got my verbal instructions, that a divorce case has been disposed of, and my lord, when she tried to revive it, there are orders which can place on record. The family court had to have her arrested because she had attacked me physically inside the court itself. Those documents, my lord, I have not placed on record as of yet, because I received them about a week ago. And that would only provide another opportunity to respondents to prolong the matter by trying to verify those. But as of today, my lord, they are deducting that 22%
without following the very procedure laid down by the SOP. I am paying my maintenance to my wife, which was awarded by the family court. Lordship would also like to see the at page 21, the clause F. Maintenance allowance, I'm sorry, clause G. In case where it is clearly established that the wife is living in adultery, or if without any sufficient reason she refuses to live with her husband, or if they are living separately by mutual consent, she should be advised to take recourse to court of law. The reports given by the commandant of by the captain at page 49, my lord, which I have shown, he says that there have been several requests by the department itself for her to come back. She did not even respond after that one particular application filed in the year 2019. And I continued at 2015. They revived that maintenance in the year 2020. And they continued to deduct it and send it to her. Their powers to recover under section 69 of the Assam Rifle Act is not in issue.
So,
could they have done it in the manner they have done it?
one thing. Please come to annexure B of your app.
Annexure.
Is at page 19 or 18, I don't know. It is here in page. Running page is 18 and 78. Internal page is 18.
Placement with respect to grant of maintenance allowances to wife and children and combatant Assam Rifles personnel under Assam Rifle Act 2006.
Please read. Para 3.
Para 2.
Yeah.
In this regard, as respect to next page, my lord. Seven, my lord, clause 7. Because where the matter has already been executed upon either under criminal or civil law or order has been passed, which the individual does not honor, a case for sanctioning maintenance allowance will be initiated accordingly.
Fine. So, clause 7 of that 2011 policy in the letter of your authority of 28th of January 2014. Okay. Now, please come to the repeating.
From the page.
You can read Hindi. Devanagari you can read.
Hindi.
Devanagari you can read only.
Hindi.
You can read.
No, my lord.
You know. I don't know Indian language.
Not thoroughly, but he can.
Come to page number 31, translated. 31. Read petition.
Thirty-one.
31.
So this is
read petition.
Read petition.
Yes, my lord.
See, original case 336 of the 2016 was preferred by under section 9 of the Hindu Marriage Act by the petitioner against his wife.
Yeah.
Now this Miss case 21, in which the order was passed. We come to that later. It was a Miss case that was filed by the wife.
Wife, my lord.
Now please come to page number 34. The prayer made by the applicant, you can read, right?
Yes, my lord.
And the 4,000 per month was given as a maintenance allowance. On which date? See the date,
It's 11/5/2017.
11/5/2007. Now please come to your order at page 38. It is of which date?
It is March 2021, my lord.
No. Page 38. Read petition.
38, my lord. Yes, my lord.
Which date?
10th September 2017, my lord.
So the maintenance that was granted by the family court was of 11th of May
Earlier,
2017, and your order was of 10th of September 2017. Now please come back to page number, your annexer B. Just now you read,
B, my lord. Yes.
right?
Yes.
2, page number, annexer B, page number, running page number 19,
Yes.
your affidavit,
Yes.
clause 2. When the case for grant of maintenance, it should be maintenance, is sub judice, but no orders have been passed by the court on grant of maintenance. The competent authority may grant maintenance as per this department policy letter, such and such. So, in terms of this particular letter of 2014 January,
Yes, my lord.
before you pass the order, before it is on July
10 September 17.
September 2020, 10 September 2017, maintenance was already allowed the wife of the petitioner by the family court on 11th of May. So, in terms of this letter of yours and the clause 7, whether you could have passed this order of 10th of this order on 10th of September, page 38. Policy at clause 7, the letter of January 2014.
Clause 7, when it says that it cannot honor,
Because, yes, my lord, this has been passed.
Could have been passed.
Granted by the family court
It was prior.
prior to that.
It is not.
But
the
it is
case-
not honored.
It is not the case that the matter of sub judice and no order pertaining to the maintenance was passed. No order pertaining to the maintenance, but much prior to the order of 10th of September. The month of May 2000 itself, 2017 May, family court adjudicated the matter and granted maintenance. But the clause says, up to this, no order of maintenance. In that case, yes, under that policy, you can maximum of 30. Now, when the order has already been passed by the family court, granting maintenance, whether this order will survive 10th May 2007,
My
which you
lord,
have again modified in 21.
if he does not honor the order of the honorable court.
That is not the that is not the case. If the order of the family court is not honored, that is not your policy. Your policy, if the matter is sub judice, no maintenance is given. No order of maintenance. An order of a court is not complied with. That is sufficient. If there is different
Well,
proceeding altogether. Your policy is totally different. If you read clause
My lord-
7, that 28th of January 2014 annexer B and clause 7, where the matter has already been adjudicated upon either under criminal or civil law, an order has been passed which the individual doesn't honor, a case of sanctioning or maintenance allowance will be initiated accordingly. You are saying that.
My lord, just their affidavit for once, my lord, they have admitted that I have complied with the orders of the family court. In their affidavit, they are saying so.
Where
My lord, page 71. Page 71, my lord. The second paragraph starts with moreover. From the top 1, 2, 3, 4, 5th, 6th line. In the middle, as the petitioner has already been paying maintenance allowance with effect from 18 July 2015 at the rate of at 22% rate and under order of 10 September 2017. The Honorable Family Court order dated 11 May 2017 for grant of interim maintenance stands already complied with. However, the petitioner was required to pay only rupees 4,000 from the month of so and so, not the amount as directed by Assam Rifle. Therefore, they review it. The maintenance allowed by the family court has been paid, deducted, done with. It is not the allegation that I have not paid that amount.
Where
As the petitioner has already been paying maintenance allowance with effect from 18 July 2015 at the rate of 2% out of his pay and allowances as per Assam Rifle Authority's order dated 10 September 17. The Honorable Family Court order dated 11th of May 2017 for grant of interim maintenance stands already complied with. However, the petitioner was required to pay only rupees 4,000 per month from 8 February to 11 May 17 and not the amount as directed by Assam Rifle Authority. So what the Assam Rifle authorities are trying to do is, for that interim period, you will pay what the court has told you, rest you will pay what we tell you. That is not the power given to them.
Because SOP says, my lord, 20% for the
a maximum 22%,
maximum 22% for the wife minor.
If I do not comply.
See, there is a difference. Maintenance under section 125 CRPC and maintenance under the domestic violence. The Honorable Apex Court has shown the difference. Wife can also claim maintenance under section 125 CRPC and also under domestic violence. There are certain issues raised that how can we pay twice? But Apex Court has asked, no. They are two different matters altogether. One is under the domestic violence, the other is staying under the CRPC 1 section. But here is your policy. It's totally different. When there is no such order in favor of the wife for maintenance by any or any education is happening, no such order of maintenance. In that case, you can deduct up to 2% of salary of serving you. That is not the case. 10th of May 2017, Family Court adjudicated the matter, directing the petitioner to pay 4,000 rupees per month. In above date, how can you pass another order for reduction of 22% of the salary of the petitioner plus the maintenance of the private? Well,
It may be wrong, my lord. Court order or another court order is will charge.
where is the proof that he did not comply with the order of the family court? Where is that? If you are saying that in compliance with the clause 7 of the policy decision, you have deducted that. Where is the proof that he did not pay 4,000? There has to be something before you.
But the monthly allowance are given by the family court from where to deduct. If he is not honored the order,
Where is your proof in that regard Platform you found.
It is family court order directing the respondent, directing the petitioner to pay 4,000 rupees per month.
Now, where is the observation made by the family court that the petitioner did not pay that 4,000?
But the arrear was there, my lord. We have deducted the arrear, and now from where to deduct it? From the salary or the? Otherwise, he will not honor the order.
Deduct 4,000 rupees.
If the
How can you go for 22%?
there's no difficulty.
Your lordship, please.
Think over, tell us. We'll definitely.
My
pass
lord,
you.
he is admittedly she is the wife of petitioner.
We are
my
not
lord.
on that track. We are not on that.
Is entitled for maintenance, my lord. But
Court have already,
maintenance,
family court have already adjudicated.
yes, my
Now,
lord.
where is the finding that your wife was a teacher or something earning salary? Where is
Madam, that I had given that allegation that she's working as a teacher, it is there. For the SOP, they were required to call for an affidavit regarding her maintenance. Lordship will kindly have that
in the policy?
in the policy. That affidavit was never called for from the wife. Instead, at page 53, my lord,
We'll do one thing.
at page 53, the commandant says that we have tried to communicate with the wife. She does not respond. Even now, my lord, I have taken dusty service. Proof of service is there. My lord, the deemed service has been accepted. She is not before this court also. That one application giving her around 25,000 a month from my salary, she is satisfied. She is sitting home. She will not contest it anywhere. She will not go back to the department. She will not come before this honorable court. She is not appearing in the other high courts where I had filed the divorce petition. In fact, she had to be arrested by the family court at one point of time. Affidavit, they have stated that I have made the specific allegation that she is a teacher, but they do not say that they have made any inquiry regarding the same. That admission is at page 74, my lord. That they know. I have asked them. Page 74, para 11, that the amendments made in paragraph so of the petition are partially correct. However, the petitioner has modified many facts of the case in his favor to gain sympathy. It is submitted that after receiving application of 18 July from the Srimati Tanu for grant of maintenance allowance, respondent authority served show cause notice dated 17th of December 15. In response to the show cause notice, petitioner by this letter on 2nd February 16 intimated that Srimati Tanu is working as a teacher in a local school and she is able to bear her own expenses.
On the next text, the
I'm serving under respondent number 5. The person who has passed the order is respondent number 4.
The respondent numbers 4, 5, and 6 shall place the relevant records in original. 1, 2, 3, 4. Which are as follows. 15066/A oblique main MAIND maintenance of main test 12 AR oblique 2015/2003 dated 17/12/2015. Very important. The following Administration for Inspector General Assam Rifles within bracket East. This should be communication on 7/12/2015. To 1551. Oblique maintenance dash MC oblique 12 AR oblique 2017 oblique 48 wherein the colonel administration for Inspector General Assam Rifles South Headquarters Assam Rifles for the Inspector General Headquarters Assam Rifles South on 10/09/2017 issued a communication to the communication. List on 3rd of August. Copy of this order to Mr. Director and its DC appearing for testimony. Original.
Bless you.